Lordship one statutory appeal Lordship, admission column Lordship, and then second Lordship, 2nd of March. Because Lordship, it was listed only on last 17.
I can understand.
Yes.
Listing to what to do. We have many matters have already been listed. For mentioning, I have allowed since last week. Many matters have been allowed for listing. Okay, then, okay.
Yeah, please, Your Lordship. Lordship, praying for listing of a criminal petition next week, any date, Your Lordship. Any date, Your Lordship.
6th of March.
May I please, Your Lordship. Lordship, I beg to mention for item number 26 of the daily list, Lordship. Lordship, yesterday in this case, an additional affidavit was filed. Lordship may allow to call. Yes, Lordship. Lordship may allow to call for the record, Lordship.
Additional affidavit.
Additional affidavit annexing the petition, Lordship.
May I have your Lordship? Lordship, I beg to mention for listing Lordship at 2 Lordship. Unlisted matter. There is some urgency, Lordship.
Not at all. I'm
Lordship,
going-
petitioner
I'm
is a
going
67
early.
years old Lordship. But
No listing will be there.
some reason.
What kind of bail matter?
Yes, Lordship.
Sorry.
Then tomorrow,
What is
Lordship,
the urgency? What is the urgency?
urgency, Lordship, what is the matter? Actually, Lordship, 1, 9 and 13 petition, the IO was visited to the petitioner's house to arrest the petitioner's son,
Oh,
Lordship.
it is a PRS.
And
not-
Lordship-
Nothing urgency.
And
No
Lordship,
urgency is there at all.
and
It will
Lordship,
be on second.
the petitioner's son
2nd
also.
of March. No urgency. That kind of. matter is
Lordship,
not
kindly
urgent.
tomorrow,
Second
Lordship.
March.
Petitioner is 68 years old, Lordship.
2nd March.
May I plead to Lordship? Lordship listing for mention anticipatory bail for three.
Hmm?
Three anticipatory bail application for tomorrow,
The
Lordship.
anticipatory bail
Anticipatory
application. Tomorrow, not at all possible.
Because has been
So what will be the reason?
has been
Not
notice
at all
served to the accused person for
So
appearance
whatever, We
27.
are not positioned to list it tomorrow. Not at all. 5th. Either 5th or 6th.
Keep.
5th.
May I please, Your Lordship? I beg to mention item number 16, my lord.
খবর করবো, হ্যাঁ, আমার
16.
খবর করিব। এই খবর করিব। একটু পড়াবো না। ও, আর ইমাম পড়াই চলছে। করিব। Students কে একটু করিবই রেখে না। আমি তো exclusively bail করি। Yeah,
May I please, I beg to mention item number 16, my lord. 16, my lord.
1/6.
16. Case diary has not been received, my lord.
Huh?
Lordship, may I have another date, my lord?
Not
Yeah.
received.
Not received.
You are in custody.
Yes, ma'am. In interim, I have interim.
You are in injury.
Yes, ma'am. Sorry.
She did not receive this reminder when it is.
Last week of March, my.
May I please, Your Lordship?
It's an interim
May
order,
be
ma'am.
continued till next day.
Of last week.
May I please, Your Lordship? Lordship, I beg for listing of 2 criminal petition. Lordship,
No.
criminal petition, Lordship. Lordship, it was not listed as per the previous order. Lordship, kindly listed on 2nd week of March, if possible.
11th of March.
May I please, Your Lordship? Lordship, I pray for listing of a fresh criminal petition tomorrow, Lordship. Lordship, urgency is that, Lordship, the matter fixed in the lower court tomorrow, Lordship. So
No, cannot.
distress
You
warrant.
cannot just. Tomorrow somehow you manage it there. No urgency. When it can be. 6th of March. at least.
Lordship, I beg to mention for withdrawal of a bail application. Case
Tomorrow.
number 3961.
Tomorrow.
Tomorrow.
May I please, Your Lordship? Lordship, I beg to mention item number 14, Lordship.
1/4 or 4/0. 1/4.
1/4.
Acha.
So this matter may be passed, fixed after 2 weeks, Lordship.
You are for the petitioner?
Petition.
At the request. Have you informed is the PP is there and
Please.
standing council forest is there? Just inform it, huh? The standing council. With the consent of the.
So one interim order is there, maybe I'll continue.
Wait for an adjournment. Drag around. List the matter accordingly after 2 weeks as an reports by the ministry. You are interim is there.
One interim order is there.
Interim
Maybe.
order be continued till next date.
May it please your lordship. Your lordship, I beg to mention for listing of one criminal petition, my lord, for orders. Please kindly give a date.
10th of March will be.
Yes.
May it
obliged.
please, Your Lordship? I beg to mention for withdrawal of a criminal petition tomorrow, Your Lordship. Thank you.
May I please your lordship. Lordship, I beg to mention for listing of one criminal revision petition for admission, lordship, on 6th of March.
9th of March.
Obliged lordship, I plead for lordship. That's why I beg to mention listing for a criminal appeal lordship. It was last posted on 5th of
In which
December.
column?
Lordship,
In which column? Order,
Orders.
admission,
orders.
Huh?
Orders column.
orders column. Maybe on 9th of March.
9.
May I please, your lordship? Lordship, in item number 23, I have filed additional affidavit, lordship. Kindly put for,
You have already filed.
yes, lordship.
Okay, we are calling.
Obliged to.
এটা নোটিস একটা করাই দিব মোট সাইড অফ পুরো এটা বক্স কেন দুটা বছর কোর্ট উইল রাইজ এট ফাইনাল
Lordship.
Yes.
Lordship is the third time bail application, Lordship, by commercial quantity of NTPS, Lordship. Lordship, with this case, Lordship, I am behind the bar, Lordship, 2 years, 6 months, 23 days, till date, Lordship.
2 years.
2 years, 6 months, 23 days, Lordship. Lordship, in this case, Lordship, on the last order, Lordship, of this honorable court, Lordship, please come to page number 64, Lordship.
Yes.
Yes, I'm coming from the upper part, Lordship. Accordingly, the court of the learned special judge is hereby directed to complete the remaining witnesses within a reasonable period and to try to dispose the matter, preferably within a period of the 6 months. Lordship, already the court examined the delay of the trial, Lordship. Now I'm coming to the Lordship, page number, Lordship. Lordship, on page number 65, Lordship. On next page, Lordship. Lord, this is the last order of the trial court, Lordship. May I read, Lordship? On 17/2/2026, the order passed, Lordship. Accused persons as Sokib and Vijay Gupta are produced before judicial custody. Today, the matter is fixed for the prosecution evidence. However, no witness is present. A petition bearing number this is filed on behalf of the complainant, stating that Sri K.B. Robinson, the superintendent of the NCB Gauhati, has been transferred to Itanagar, where he has joined 16 to Ratna, and as such, he will not be able to appear today by said petition number adjournment is so. Record reveals that so far only 4 witnesses has been examined and last witnesses were examined on 3/5/2025. The accused persons are released in the jail. Issuing summons to the witnesses, complaint NCB is to take steps, and also NCB is directed to ensure presence of the witnesses positively on the next date of hearing. List a copy of this order on recently to Journal Director NCB dated accused persons as shopping and remanded to justice. Now now to come 26 to for fixes for the production and 26/3/2020 for the prosecution witness. That is more than, Lordship, near about 7 months, Lordship. Same stage, Lordship. On the last occasion, when I was filed this bail application, Lordship, same stage is still now in the trial court, Lordship.
Till now, how many witnesses, sir?
Same witness, Lordship. Four is only near about 4 witnesses left to examine.
Lordship, may I draw your Lordship's attention to page 61, part of the same judgment, paragraph 10 of your Lordship's judgment. Wider delay. Lordship has noted paragraph 10 in the middle portion. Thereafter, the case was accordingly fixed for evidence. From record, it reveals that on 4-5 consecutive dates, the learned counsel for the defense did not appear, for which PWs who were present before the court could not be examined. It is not a case that the matter has been intentionally delayed or something. Counsel for the defense is not present. Now, admittedly, the officer has been transferred. Today is for production. Out of 7 listed witnesses, 4 have been examined, and Lordship has mentioned that in this order itself, that out of 7, 4 witnesses have been examined. And Lordship, at least now it will be the 5th witness. 3 witnesses have to go. I do not think that would be a ground to grant him a bail.
Lordship, I'm coming to Lordship. On the last occasion, Lordship, the same seems to present, Lordship, to the delay of the defense counsel, Lordship. But their Lordship, it is with due respect, Lordship, it is not fine that how much date, Lordship. Whether in that very date any witness or present, lordship. Yes, this is having to that we are giving the petition. We know from that a witness is not, that's why we are presenting the petition. But whether any witnesses, if any witnesses were present, lordship, as I stated on the last occasion, lordship, the only that, lordship, some fines would be having implicated on us, lordship. But on that occasions, lordship, after all these things was on the last bail application, lordship. After that, this honorable court, after that, lordship, by going through all this, lordship, even a 6 months, not only to complete the evidence, lordship, to finish the case, lordship, not only to complete the evidence only part, lordship, to finish the case, lordship. Now again, lordship, having the trial court also, lordship, there comes on that. He was several date he was not present and he transferred to that date. It is stated there, lordship. On the last occasion also he was not present. But here thing is that, lordship, if we are giving some petition or anything, lordship, now the thing should comes out, lordship. This is having a part of the last occasion when the bail petition was filed, lordship. Yes, I am making this ground before this honorable court is that, lordship. The honorable court have given a direction, lordship. That's why this is become a grounds, lordship. And here the thing is, lordship, not is 6 months. Again, the matter is fixed on 26/3, lordship, for having the evidence. And he was already transferred to their lordship. In between of the time, lordship, I'm only asking the bill, lordship. 2 years, 6 months, 23 days, lordship. And in this entire case, lordship, I have a submission, lordship. I do not have any background that my family members or I have any PS, lordship, related to NDPS or anything, lordship. I'm totally free on that, lordship. Only having this case. I'm submitting this only falsely implicated. I mean, this case is that, lordship. I do not have any background of the having another case also pending in the another case, lordship. It's totally clear. I am coming this, lordship, only having a thing is that, lordship. Yes, if something has happened on the last occasion, it is having a submission on that very bail application, lordship. But now, lordship, I am presenting only having on that bail order, lordship. And if, lordship, delaying from the defense side, lordship, whether have anything order, lordship, whether in that very date also the evidence has come. And due to the delaying of the defense side, they return back. This is not, lordship. Only thing is that is reflected in there. But after that very all things, lordship, now freshly I am coming, lordship, on having this order of this honorable court. Honorable court given the direction that, lordship, within having a period of the 6 months, evidence is finished and to finish the entire case, lordship. Now I'm
Yes.
coming to know.
Now, lordship will see when the matter was fixed, lordship will kindly see page 65. The PO was on leave. Next order, lordship, yes, the officer has been transferred out. Now, who is taking more time? As reflected in the earlier order, you were not there for 4 or 5 days.
He is not on that. His submission is that 4 or 5 days, these are things are already considered in the while
Yes,
rejecting the earlier bail application.
that,
Now he is the situation that in spite of the direction of the court for within
now,
6 months,
court,
till now the prosecutor could not even examine a single witness.
how
That
many
is his
dates have
submission.
come? That is, lordship will call for the records. Lordship will see how many dates are there. How, after passing of your lordship's order, was there any endeavor? That is what your lordship will see.
We'll call for the record.
Yeah,
We have to
lordship,
just to come
see,
from
I have one
our
only
back.
submission, lordship. Only one submission, lordship. The evidence was started, lordship, on 21/3/2024, lordship. 21/3/2024 evidence was started, lordship. Now on the say, lordship, how many date? This is not having a things from outside, lordship. If having the intention to finish the case, lordship, or to call for the witnesses, it totally depend upon the trial court, not from the defense side, lordship. This is not from the defense side.
Lordship, I have
Because
got
I have a submission, lordship, with due respect, lordship. If the court given order, lordship, to finish the things within the period of the 6 month, lordship, then that very order should be passed in the trial court. They will give the short date, lordship. They will try their best to finish the evidence, lordship. But I am annexing this order. Only having a thing is that, lordship, what is the reason behind it? My submission is totally based on the trial court last order, lordship. Lordship, I have a submission that's a very long time, lordship, 2 years, 6 months, 23 days. I'm not going on that very part, lordship, how I involved in this case, lordship. I'm not going to do that, lordship. 2 years, 6 months, and 23 days, lordship. In the meantime, lordship, I lost my father also, lordship. That time also, I'm not getting the bill. And here I did not have any past record also there, lordship. I know any family members also there do have a record, NDPS or any case, lordship.
Okay, where from it has gone?
It will be from the court
Kamar
of the,
Metro?
yes, lordship, yes, lordship.
We are trying to give a short date. Your next date is fixed on 26/3.
26/3, lordship.
Today is for production and 26.
No, not today.
Yes, Today is 26
Yeah, 26-3 is a
And the order was passed on which date?
17.
17-2, Lordship.
Twelfth of March,
That's fine.
this 12th of March.
Obliged, Lordship.
Scan copy along is ready because from the learned trial court below, the registry will look in the further the non-special judge is hereby directed to furnish the case to furnish the case record positively on or before the next on 12th March.
I'm deeply obliged, Lordship.
RKD. Senior advocate. RKD. It could be a
My lord, this is an application of 482, my lord, without FIR, my lord. My lord, I am a resident of Gauhati and my friend is permanently resident of Jorhat. He is a deceased, my lord. We are very friendship had once upon a time because both were drug addict and alcoholic, my lord. We were in the rehab together. But since I have get relief from this habit, but my friend could not, my lord. On 20th of February evening, my lord, that very friend asked me for some money. I declined to pay because I know he will enjoy the money with again alcohol. Then, my lord, another friend, Saurabh, called me that they are enjoying the alcohol, my lord, in the evening. Then, my lord, I have did not give any comment. Then, my lord, at 8 or 9 p.m., my lord, Saurabh again told me that he is very serious and has become serious and taken to the hospital at Gauhati, and he was admitted at the local hospital of Gauhati, my lord. Where, my lord, in the morning, my lord, he succumbed, he died, my lord. And my lord, in the meantime, my lord, I got a telephonic call from 21 February at 4 a.m. from his girlfriend that he is no more in this world. Then we rushed to the hospital, and after postmortem, dead body was taken to the Jorhat for cremation. But now this, my lord, there is no FIR, no GD&T, no UD case even. But district police is asking me constantly to attend the police station. I am a student of local distance education, my lord, Bachelor of Social Science. I am in 8th semester. So, my lord, I have come before your lordship, my lord. Kindly call for the CD, report from the district PS whether any case is against me. Otherwise, my lord, I am ready to surrender if there is a case. But till this any report come, I pray for your lordship to give me some protection, my lord. I am a student. If I arrested, my lord, it will damage my career.
My lord, matter relates to death of a person. So, my lord, other I will have to get the report. And if my lord CD case registered, then I will get the CD, my lord.
Yes,
Because,
kindly.
my lord, one person, my lord, died. So, without CD, my lord, my prayer before us at this stage, no interim may be granted.
My only prayer, no coercive action. Only no coercive action.
No, my lord.
That is interim.
Yes, yes.
Have you received any notice from your side?
No written, my lord, but I have been called by the police. You come and visit the police station. We have to interrogate you.
Considering the fact
How he died. Because he was very good friend once upon a time. We were both alcoholics. We were in the same rehab. But I left, give up the habit, but he could not. He is a musician at Gauhati.
at this stage, only a report may be called for, my lord. And if, my lord, any case registered, probably, my lord, in this case, from the facts itself seems that, my lord, some case probably may be registered, my lord.
No, no case has been registered. No UD case has been registered. Otherwise, no GD even. Otherwise, I could have bring those things.
Any short date may be fixed. I will get the report, my lord. If any case
Yes,
registered,
yes.
then I will get the
Kindly call
report.
for a report from the district police and no coercive action. Even if I have taken to the hospital, police station, no coercive action will be taken against me.
Well, at this stage, because matter relates to that of
No,
person.
I am only praying for coercive, not arrest. Suppose
No,
I
no,
may be
coercive
tortured.
action.
I may be tortured. That's why.
Well, same, well, coercive action, my lord.
You see, I am also once upon a time I was also drug addict.
Well,
Now
at
I
this
have
stage, I will only get the report. No interim may be granted, my lord. On
interim,
very
not
short date may
bail.
be
I
fixed.
don't pray for interim bail. No coercive action. I will visit
No
the police
coercive
station.
action, my lord, amounts to interim protection, my lord. Otherwise,
People. Till another day, PP every month. Different application, 6 or 8. 2023 for issuing direction to, no, so and so for seeking pre-arrest bail. Apprehending arrest in connection with dispute PS case number, if the apprehending arrest in connection with dispute PS case, dispute PS case is submitted by Mr. Biswas that one person died who was one of his best friend. Has no, has not done any, no, but he is not involved in his, for his death, for the death of his friend. However, police is searching for him and asking him to appear before the police station over delay, for which he may be provided. Mr. What could the land direction be submitted in this regard that he may call for a report from the police station as to whether any case has been registered against the petition in the dispute police station. However, it is of the submitted that no interim should be provided. During the submission, so let the report be called for from this police station as to whether any case has been registered against the petition. Until the receipt of the report, police from this group PS is hereby directed not to take any coercive action against the petition. 9th of March, will
Yes.
you'll be on.
May I please? My lord, this is an application under section 528, my lord, for seeking Jimma of the seized articles along with the case.
My lord, in this case, scan copy of TCR received, my lord. I need, my lord, sometime. Your lordship may fix it at 2, my lord. I will have to go through the scan copy, my lord.
Better not to fix at 2 because I have some
Yeah,
other
yes.
case, so
If
I want to
possible,
try
to
a bit
Yes.
early.
Yes, my lord. Any other day,
So-
any article.
10th of March will do or?
Yes.
10th of March, my lord. 11th of March, if possible.
11th of March. The request made by learning council for the learned edition review matter be listed on that 11, you've said. 11.
Highly able.
My lord, matter may come up for, my lord, admission, my lord.
In admission.
Oh, Jimma. Yes, yes, my lord.
My lord, matter may come on motion also, only for Jimma.
Motion,
Yes, yes, motion, motion.
Highly obliged.
May I please, your lordship? Lordship, this is an NDPS case under section 20C, and I am praying for quashing of the charge sheet that has been filed subsequently. Lordship, in this case, there are 4 number of accused total, out of which I am appearing for three person against whom 2 numbers of charge sheet has been filed in 2 different districts arising out of the same seizure that took place on 6/8/2022. One in the district of Bajali and the other in the district of Nalbari. And the petitioners are appearing in both the 2 districts and facing trial. I am praying for quashing of the FIR that has been filed subsequently in the district of Bajali. Otherwise, this will go on, supposedly if the accused persons are convicted in one of the case. In both the cases, they will face punishment twice pertaining to the same seizure, which will amount to double jeopardy or will go against the constitutional mandate, lordship. Lordship, I have annexed the charge sheet, both the charge sheet. In page number 29, it is a charge sheet that has been filed before the learned trial court of Bajali. Page 32 consists the gist of the allegation. May I read the gist of the allegation?
Where is the place of interception, etc.? These are different or same?
Same. Same lordship, everything is same. It's like lordship, 3 persons are apprehended at Tihu Chowk, wherein these 3 person has confessed that some other person confessed of taking the contraband from some other person who resides in the district of under the jurisdiction of Bojali district. And thereby these 3 apprehended persons were taken to the Bojali district, wherein another person was apprehended and seizure was made from there. And accordingly, these 4 persons were arrested and produced before Nalbari judge, produced before Nalbari court. Thereafter, only 3 persons were taken to Bojali district and they were again produced there. And both 2 charge sheet has been filed subsequent. One in the Nalbari district and other Bojali district after 1 month of filing of the Nalbari district.
No, at this stage, my pair, both scan copy may be called for. Scan copy of the PCR of both the cases. Because GD entry is same, my lord.
Same GD entry
Same
filed
GD.
by the same complainant. Even charge sheet filed by same IO.
Same IO cannot be.
Bhaskar Jyoti Deva.
Informant is same.
Informant is same.
TD
But
Kumar.
maybe same, but
Same.
one, the charge sheet was filed by under suppose Bojali police
Yes.
station, or in the other one, it is
My lord,
submitted
one,
to Nalbari.
initially, my lord, contrabands were recovered from one auto vehicle, my lord. And thereafter, my lord, in the particular district of Nalbari, my lord, Tiho. Thereafter, my lord, on being interrogated by those accused persons, later on, one Koilas Das was arrested in Borpeta, my lord. And thereafter, in both the cases, informant has lost the affair, and in both cases, charge sheet submitted.
Oh, this, they may be apprehended in one place. Obviously, recovery may be from the other place.
Yes,
Immigration issues are also
Yes,
there,
yes.
but, how two charge sheet can be filed?
Yes.
Yes.
That is questionable.
Yes. Well, both scan copy of both TCR may be called.
Now, what are the cases is as at what stage now?
Evidence.
Both the cases are in evidence stage. So why you have come so late? No, but see, there is coming because if they for the same cause of action, for the same list, 2 cases, that should not be.
Yes.
Because obviously that, but you have come late. Anyway. Hard MS elbow, the learned counsel for the petition. So hard to be what the learned petition PP appearing on state respondent.
May I your lordship, my lord, in case of any stay, my lord, only in subsequent case, my lord. That is, my lord.
She is not
Oh, yes.
That's
really.
No.
I was about to. Lordship, the Bojali, the case pending before the learned trial court of Bojali, that may be stayed for the time.
No, otherwise, my lord,
Otherwise-
considering the nature of offense, at this stage, only scan copy of TCR may be called for, my lord. Later on, after perusing the case diary, my lord, regarding stay,
Because it is a case of NDP.
NDPS, yes, my lord.
Stay will definitely.
Yes, yes. Yes.
But obviously she has a reason because
Yes.
cannot be.
Only after perusal of the, my lord, TCR.
You try to get the case diary
Yes.
by 6.
For the time,
Yes, yes.
Lordship,
No.
the case pending before the Bojali court, although the case is fixed for evidence stage, witness have not turned up yet. So I say maybe saying that particular case will be like is needed at this stage.
Now your petition is
Crucial,
for
Lordship.
quashing off on Bojali only.
Yes. It's crucial because if evidence is started, the case will take a different time.
Bring for quashing the and within the case 01 of by CS number 1188 dated 31/11/2022 pending before the learned court of district and session just for issue notice to the respondents. No formal notice is required to be served on state respondent number 1 and 2. A copy of the petition may be served in court. Next, it is submitted further by Ms. Bonik that the 2 cases has been registered against the 3 petitioners. One is pending in the court of Bojali, district and session judge Bojali, and another case is pending
Well,
before
uh,
the learned session judge. No, where is it? Other cases
My
pending.
lord,
Borpeta or
my
Nalbari?
lord, I would like to
Nalbari.
point out one aspect, my lord, because now he has challenged only the case of now pending in my lord Borpeta,
Yes.
Bozali, my lord. So now he has not, my lord, challenged the case which is pending at Nalbari. So your lordship cannot call for the, my lord, scan copy of the TCR from Nalbari.
No.
Because my lord, she has only, my lord, challenged the, my lord, case which is pending in Bozali, my lord. So your lordship, only TCR of the Tihu can be called for by this, at this stage,
But
because.
the plea is a bit different. Within this plea that the two cases are pending out of same cause of action, out of same seizure list, and
Yes.
ECA of what is there.
Yes.
So in that case, if you don't go by the cases of both the FIR or the charge sheet, it may be problematic.
Yes.
For that reason only we have to
Because-
qualify.
Yes.
Now, other one is pending before which court?
And in the learned court of Nalbari.
Because
Have you
regarding
mentioned
that,
here?
regarding that,
Yes.
she has not filed any case.
Yes.
Lordship, I have filed an additional affidavit fixing the Nalbari charge sheet. Oh, additional
Have you
affidavit.
provided the case number of Nalbari?
1/23, NDPS case number 1/23.
No,
In
that
both
is the
the,
Bojali.
in Nalbari also 1/23, Lordship.
One of the 20.
Lordship, in my additional affidavit I have submitted.
Oh, where is the case number?
Lordship,
We
I have
call
mentioned
for
the charge sheet
investigate-
number.
Charge sheet number will not do.
My lord,
We'll go for.
yes, at this stage, my lord, only scan copy of the TCR of the present case may be called.
No, that cannot be.
That can be only called for, my lord. And at this stage, my lord,
On
only
basis
after
of charge
provision.
sheet, we cannot.
Aye. And at this stage, my lord, no
Submitted,
interim order may kindly
submitted
be
that,
passed.
Two charges has been filed. One in connection with Nalbari PS and other one is in connection with PSM work. That thing is so confusing. FIR was of Borpeta PS.
FIR filed one before Tihu PS and another before Barpeta PS. Are arising out of the same GD number.
No, but Borpeta is now
Now
Bozali
present
PS.
case is of Borpeta, my lord.
Originally cases of Borpeta PS.
Borpeta.
Nalbari. It originally the initial apprehension of the arrested person were took place in the Tihu Chowk polling.
Under Nalbari PS.
Yes, initially first FIR was registered under Nalbari PS. Thereafter, another FIR was registered under Barpeta PS. I have annexed the Nalbari
Borpeta,
FIR filed before the Nalbari PS Lordship.
both the cases have been pending. One in before the annexation was Nalbari, the one is in pending. The annexation was session of the special judge. Submitted that the street news petitions were awarded should arrested in connection with both the cases. Out of same for the petition and for from the same seizure list. They submitted that the second or the subsequent just maybe is liable to be quashed. Therefore, submitted that the case which is pending for the Bozali special judge. So and so special judge, complex session judge, maybe state of the state still disposable of the petition. Mr. Botkus submitted that there is no mention about for the non-very PS at the stage. Now the case, number of the cases have been mentioned in here. He submitted that case record of TCR, scan copy of the TCR and with the may be called for in connection with corporate case, which is at present pending before the session that of special judge Bozali. Let the scan copy and a scan copy of the TCR along with the case data be called for in connection with record or NDPS case number 01 of the 2023 pending before the court of learned session judge of the special judge project. And the further proceeding of pending before the special judge Bozali may be stayed till next date of listing as it is stated to be the subsequent, it is stated to be instituted on the subsequent FI. Disseminate accordingly after 3 weeks as date to be by the registry. Further registry is thereby directed to call for the scan copy of the PCR along with the case diary in connection with NDPS case number 01 of 2022 pending before the court of learned special judge of the session.
Bye.
My resolution. My lord, this is a criminal petition under section 528 BNSS, my lord. By this application, we are praying for quashing of entire proceeding of one CR case 533/24, which is pending in the Srirang court, my lord. In this case, at page 4, para 2, I have stated the facts of the case, my lord. I'd like to read out the same, my lord. The petitioner begged to state that they are accused in CR case number 33/24 pending before the court of the learned subdivisional judicial magistrate Srirang arising out of complaint filed by respondent number 2 under section 296/115, 286, 326, 329 subsection 3, 324 subsection 2, 352 Bharatiya Naya Sanhita 23, my lord. The fact of the case is that respondent number 2, complainant, claims to be a school teacher and alleged that on 38/24 at about 1:40 p.m. while he was taking class in Gosaigaon Senior Basic School, the present petitioners, 3 petitioners are there, are entered into school premises, assaulted him, damaged his mobile phone and threatened him. This is the allegation against all these petitioners, my lord. Now, my lord, after lodging this case, cognizance was taken and some evidence also examined. Now, my lord, under trial. My lord, I would like to read out paragraph 9 of my petition, my lord. In this case, before taking cognizance, my lord, the learned trial court ought to have follow the provisions, mandatory provisions of, my lord, section 173 subsection 4 of the BNS, my lord. And I have stated that facts in my para 9 of my petition, my lord. The petitioner begged to state that respondent number 2, complainant, has deliberately bypassed the mandatory statutory procedure prescribed under the Bharatiya Nagarik Suraksha Sanhita 23. It is settled law that where the police refuses to register an FIR, the aggrieved person must first approach the superintendent of police in writing under section 173 subsection 4 of the BNSS. Only upon failure of the superintendent of police to take appropriate action, the complainant is entitled to invoke the jurisdiction of the learned magistrate under section 175(3) BNSS. Now, my lord, for a moment, I would like to read out the provisions of 173 subsection 4, my lord, BNSS.
Yes.
May I read, my lord? Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by this Sanhita, and such officers shall have all the powers of an officer in charge of the police station in relation to the offense, failing which such aggrieved person may make an application to the magistrate. This is mandatory provisions, my lord. And kindly, my lord, page, in this case, whether they have filed any application before the SP or not, that
You're
is,
saying it is a mandatory provision.
my lord.
Where from you're saying it is a
Yes,
mandatory?
Supreme Court decision is there. I will place on later on, my lord. Before on that part, I would like to say, my lord,
Here,
kindly see page 40, where in this case,
here impugn order is at page 23 to 25, my lord.
impugn order, my lord, that is in my prayer portion included this, my lord. Kindly page 40, my lord, for a moment. Paragraph 5. It is a fact that I have not informed about the matter to the SPC rank. That is admitted. He has not never approached to the SPC rank, my lord. Now, my lord, I would like to come to the Honorable Apex Court decision, my lord. Priyanka Srivastava, my lord. Priyanka Srivastava and Ranjit Singh. And one coordinate bench judgment of this Honorable Court. Paragraph 31, my lord, Priyanka Srivastava. May I read, my lord? We have already indicated that there has to be prior applications under sections 154(1), that is newly 173(1), my lord, and 154 subsection 3, that is 173(4), present, my lord. While filing a petition under section
Which para you are reading?
31, my lord. Para 31.
Achha.
We have already indicated that there has to be prior applications under sections 154(1) and 154(3) while filing a petition under section 156(3). There has to be prior application, my lord, this line says. Both the aspects should be clearly spelled out in the application and necessary documents to that effect shall be filed. The warrant for giving a direction that an application under section 156(3) be supported by an affidavit is so that the person making the application should be conscious and also endeavor to see that no false affidavit is made. It is because once an affidavit is found to be false, he will be liable for prosecution in accordance with law. This will deter him to casually invoke the authority of the magistrate under section 156(3). That effort we have already stated that the veracity of the same can also be verified by the learned magistrate regard being had to the nature of allegations of the case. We are compelled to say so as a number of cases pertaining to fiscal sphere, matrimonial dispute, family dispute, commercial offenses, medical negligence cases, corruption cases, and the cases where there is abnormal delay, let's say, in initiating criminal prosecution, as are illustrated in Lalita Kumari Swansha, are being filed. That apart, the learned magistrate would also be aware of the delay in lodging of the FIR. Where already indicated that there has to be a prior applications, my lord, before filing 156(3) application before magistrate. And by based on this judgment, my lord, 2025 HCC online HE 1479, Ranjit Singh judgment. Kindly see paragraph 8. This is recent judgment, 25 judgment, my lord. May I read, my lord? Paragraph 8. Subsection 1 and subsection 3 of section 154 CRPC are the two remedies available for setting the criminal law in motion. Therefore, this court held that before a complaint chooses to adopt a remedy under section 156(3) of the CRPC, he must exhaust his remedies under subsection 1 and 3 of 154 CRPC. Subsection 3 is the present 173(4), my lord. And he must make those abatement in the complaint and produce the documents in support. Abatements in support, my lord. However, in this case, the second respondent did not exhaust the remedies. In this view of the matter, we find that both learned magistrate and the High Court have completely ignored the binding decision. This line, my lord, binding decision of this court in the case of Priyanka Srivastav, my lord. Earlier, I have referred. This is binding provisions, my lord. And based on this judgment, my lord, our coordinate bench of this honorable court also, my lord, in criminal petition number 118/2026, on, my lord, 5 to 26 recently stayed the entire proceeding, my lord, on the strength of this judgment, my lord.
Yes, bro.
State is the formal party. This is CR case, my lord. At
Lord,
this stage, my lord, I am paying for stand notice, my lord.
My lord, now what he has challenged, he has the order of the trial court dated 36, my lord, 25. That is annexed in. Now, my lord, in this my lord, petition, my lord, while challenging that order, my lord, now he has taken all these grounds regarding non-filing of affidavit before all these grounds. He has never taken all the grounds while at the time of filing, he was challenging, filing that order passed by the learned trial court dated, my lord, 36/25. While he has filed a revision before the Honorable Session Judge, your lordship may kindly come to page 29, my lord. Page 28, my lord. What he has challenged, my lord. That the complaint case by CR number so and so 30 is pending for disposal before the learned Shirang, 5 for further evidence. The complaint of the above number share, that is paragraph. In nowhere, my lord, he has challenged regarding, my lord, he has taken all these grounds. Now he has taken. Now here in this case also he has challenged the order dated 36/25, whereby, my lord, learned trial court has allowed the complainant to, my lord, produce that video footage as evidence, my lord.
Lord,
So these are all, my lord, new grounds he has taken, my lord, at this stage, my lord. In fact, my lord, your lordship may kindly come to the present petition, my lord. What paragraph ground number page 4, my lord. That the petitioners beg to state that one witness had allegedly videographed the entire incident and such video footage was stated to be available with the complainant as mentioned in paragraph 7 and paragraph 10 of the complaint petition, but deliberately failed to produce the alleged video footage during examination in chief or at any subsequent stage when full opportunity was available. However, after substantial progress of the complainant evidence, the respondent number 2 filed petition. So matter has already substantially progressed. He has not taken all these grounds that at the time of filing complaint, there was no additional affidavit there. The complainant has not approached before the SP. Now, my lord, he has taken all these grounds while challenging the order dated 36/25, my lord, passed by the Honorable Trial Court, and that was in fact affirmed by the, my lord, Revisional Court, my lord.
And in 36/2025 order, these discussions are not there.
No. In
It's
revision
completely different from regarding
This
the
is-
video clipping and all.
yes.
This is true that this plea was not taken earlier, my lord. Now, subject to your lordship permission, I would like to say on in support of submission of my learned friend, my lord, in opposing of submission, my lord.
In revision petition.
This is the
Now
question
there
of
is a dispute regarding the video clip and all this.
Yes,
kind
that
of-
is another.
allowed. Your lordship may kindly come to page 25. While, my lord, learned trial court has passed the order allowing that, my lord, to produce that video footage. Page 25, your lordship may come to 1, 2, 3, 4, 8 line, my lord, reverting to this instant case, my lord. While after going through the case record, it is seen that the complainant had already mentioned about the video clip and also to produce it at the later stage as per law, which means that the accused side is well acquainted with the matter of video footage and it is not a new evidence or afterthought evidence to cover up the loopholes. considering the decisions above, this court is of the view that allowing the prayer of the complainant will not prejudice the accused side. Further, the defense side will have ample opportunity to cross-examine the complainant side over the matter, and that by allowing the prayer of the complainant, it will help the court to arrive at just decision of the case, hence the petition is allowed.
And by the way, you have challenged this order only, 36.
Oh, yes, only the
36.
order dated 36, my lord, and that was also challenged by way of my lord revision petition before the Honorable Session Judge. Session Judge also affirmed the order passed by the trial court.
And the session judge order is also challenged, no?
Yes, your lordship.
Here,
that-
here it is challenged here.
Yes, yes,
Order-
yes. Session order also here, challenges here. Session order to challenge also.
That is on page, relevant portion is page, my lord, 34 to 36.
No, but you have challenged your this session judge order?
33, start from page 33.
No, no, it
30.
starts from page 33. I'm not on that. Where he has challenged it, that order also.
Oh, yes, yes, my lord.
Acha, whereby
I will
that
have-
session judge is to upheld the order.
Yes.
We're submitting on this because your challenge is mainly regarding that showing of video clips and all, whereby order was earlier passed by this court on by the learned trial court below on 4/12/2025. And that has been challenged before the learned session judge in the revision petition, and order dated 36/2025 now is your position.
My lord.
So now you are submitting all these things regarding the
Entire proceeding.
173 and all, whether it will come now, your challenge is not that.
My lord.
Your challenge is only against the order of the revisional court or the learned trial court below, whereby the order of this video clip was allowed and all on 36.
My lord.
That is the case only.
My lord, subject to lordship permission, kindly see my prayer portion, page 13.
You cannot, your prayer.
In my prayer portion, I have making a prayer, declare that complaint proceeding initiated in CR case number 3324 are vitiated in law for non-compliance with the mandatory statutory procedure under section. This is yes.
One prayer is added, you have
Yes,
added,
yes.
but your
Now,
post title doesn't say so.
my lord. Now, I want to say,
Regarding the
lord,
cognizance,
if
you have not taken any plea. Prayer is there.
yes,
I can see.
in the body of the petition is
Uh,
there.
Body of petition, there is no such prayer, there is no such challenge regarding the cognizance of
My lord.
cognizance taken without complying that 173 port.
Now I want to what say, my lord.
Okay.
Yeah.
Argument.
My lord. My lord, one line I would like to submit.
Yes, the learned counsel for the petition.
My lord, one thing I would like to submit here. I want to withdraw this petition, my lord. I would like with liberty to file in press, my lord, by correcting.
Huh?
I want to withdraw this petition with liberty to file fresh again. Yes, my lord, by correcting my cost title, my lord.
Hard Mr. Ikiaza, the learned counsel for the petition. Hard Mr. P. Waterford, the learned edition will be appearing on behalf of state respondent. And it is submitted during the deliberation of the case. It is submitted subsequently by Mr. Ajad, that there are some formal defects in the cost title of the petition, and for which he wants to withdraw the same with a liberty to file. The Mr. Waterford raised no objection to that report. Prayer allowed. Let the present petition be disposed of on withdrawal with a liberty to file a press if so advised. Okay, you are liberty to file a press,
My lord.
make the cost title.
My lord. I'm obliged.
Please.
May I please, your lordship? Now, this matter relating to Jimma of a vehicle, lordship, car. On the last occasion, lordship, a report was called
Yes,
for
yes, what
from
is
the
it?
police.
Report received.
Report is
But this vehicle
It is a
was
vehicle.
seized.
vehicle.
Car,
In
lordship.
relation to what case it was been? It was seized in
Seized
connection
on
with what
lordship,
case?
28/9/2025, your
103
lordship,
also there.
kindly come to page 21. Page 21, second line, your lordship will see, place of seizure. From the residence of the petitioner lordship, the vehicle was seized. And your lordship may kindly come to page
The case is related with a murder case.
Yes, murder case, and that offense
Murder
was
case.
committed inside the vehicle, my lord.
My lord, no, no,
Inside the vehicle.
no, your lordship kindly come to page 45. This is the impugn order by which lordship my Jimma petition was rejected by the trial court.
45.
Well, 45, last page.
Yes.
Seat belt or use করেছেন
Yes,
Okay.
what do you want to show?
My lord,
Was
as per this seat belt was used as per this order lordship. My lord, what happened lordship? The
Seat belt of the vehicle was used, my lord. That was, my lord, offense was committed inside the vehicle.
even that lordship, the petitioner lordship, he was not the FIR name equity. Subsequently, lordship, supplementary FIR was filed. In that FIR, my name was there as an accused. In such sheet lordship, no materials has been found against the petitioner. He has been lordship has not been sent for trial. And the FIR name accused of the first FIR lordship, they have been sent for trial. My lord,
case has already been charged sheeted,
yes, but the present petitioner's name has not been sent for trial. No materials has found against him.
not sent for trial.
No. My lord, the vehicle
Now
was
you are not facing trial.
no. Yes, I am not facing trial because my lord, the trial is just initial stage because the charge sheet is filed in the month of December, and the vehicle was seized on 28/9/2025.
Just tell us one thing. After filing of the charge sheet, have you approached the learned trial court?
Yes.
Yes.
You have
After
already
file- after-
No, he has not approached because that order was passed, my lord, before filing of the search sheet. So after filing of the search sheet, he has not approached before the
No,
trial.
no, after filing of the charge, 29/1/2026. This is the order.
After filing of the charge
Yes,
sheet.
and seizure list.
No, what forget about Caesar list. When the
Caesar,
charge sheet was filed.
Lordship, this was she has filed on in December, Lordship. I am saying page 24, Lordship.
24.
Caesar, she has filed on 21/12/2025.
21/12.
And after that, Lordship, I filed Jimma petition. Jimma petition filed on 3rd January, Lordship. Page 41, 42, your Lordship will find my Jimma petition.
40.
This
40.
42, my Jimma petition. This was filed on 3/1/2026 after CS. And rejection was made, Lordship, page 45, 29/1. There is, since the CS has already been submitted, what is the need of keeping the vehicle in custody, Lordship? Otherwise, Lordship, the vehicle will be damaged. Your Lordship is aware. Lordship, I am relying just to judgment of the Honorable Supreme Court.
Your lordship may kindly pay last portion of the report. my lord.
Well, in 2025, 3 SCC,
Just a second.
yes, first order. Paragraph 34, your Lordship. 34, sorry, 38. 34 in your Lordship. 34, 35, and 36. In
Yes.
Sundar Bhai Ambalal case, Lordship, para 17 and 21. With any condition, your Lordship, direct to release the vehicle, Lordship, because otherwise this vehicle, Lordship, there is no need to keep the vehicle in custody. In trial, they can take the Lordship photograph, etc., everything, and whenever needed, they can call for your lordship make impose a condition that that vehicle.
But it was a material exhibit, I think, na?
For forensic.
No. Vehicle itself is a material.
Yes. In self
Directly used in commission of
forensic
defense and
examination was
examinatory evidence. Vehicle was seized.
because offense was committed inside the vehicle.
But the owner, he was not involved. And
No, involved
whether
is
it was within the inside or outside lordship, that trial will take its own course of action lordship. What is the need to keep the custody?
Then can we do one thing? Obviously, the vehicle is there, but a vehicle was used as a material. I mean, produced as a material.
Forensic examination already my lord, done, my lord. That is the report of the
And the owner of the
Most
vehicle.
probably the trial court will be the best court.
yes.
say, at
Your
this
lordship
stage.
may kindly let them file again, my lord, one puppet before the trial.
Otherwise, there are judgments I can understand what vehicle will do. But your vehicle, entire vehicle is the material exhibit here. The entire offense was committed inside the vehicle.
Yeah.
The vehicle has already been
Well, that
forensically
thing-
examined.
Whether
So if there is
in
anything
the
but
event,
with the material exhibit, then it is
in the event, if your
because this
lordship,
is the material exhibit.
Yes, in case of modification of the my lord,
Mhm.
to be
It will
difficult.
create some
my lord,
because
in the
your entire vehicle is the material.
in the event, if your lordship assume that the incident was taken place in the vehicle, well, your lordship will consider.
No, that has already been adduced as a material exhibit. That's what I'm saying.
So-
It is not a case that your vehicle.
Yes, this is
okay.
one thing, and another. My case is only for custody of the vehicle.
Yes,
Yes,
custody
so
vehicle. That's what I'm saying. Your vehicle has already been produced as a material exhibit.
in the
Material exhibit.
yes, in the event lordship materials is there. Well, what is the
No. It's a material exhibit. Your entire vehicle is a material exhibit.
that is there, my lord?
So material exhibits
Yes.
are required at the time of production, at the time of recording evidence.
My lord,
Maybe
when
due to
the
space
vehicle,
constraint, I don't know what will be the procedure because otherwise there are many examples wherein even if for voluminous things and all, and there are procedure for taking photographs and all for the secondary purpose that can be used. These are things are there, but I don't know whether these were followed or not. Subsequently, another matter is there is a material exhibit.
Yes. Here the case is, my
This
lord,
is considered as a material.
yes.
if your lordship, direct lordship, they will do the formality whatever will require for.
No. You
Yes.
cannot follow me. It is a material exhibit.
Yes. In this case, madam, this is not related with other cases, madam, because it
In
is
other
not only
cases,
that
vehicle
vehicle
may
is
be
used for
used,
commission of
vehicle
the
may be there. The umbrella also says that, and there are many materials where why vehicle will get damaged and all. There are cases. But you're inside the vehicle, entire thing was happened. Body was carried, your forensic laboratory tested and we testified by the forensic science also. That's why I thought that the trial court will be the base court. I will reflect in my order everything that has been placed by you. Let the court be decided. If court can subsequently take some photographs and all with the help of IO and all, if that can be used as a secondary evidence, then we don't have nothing to say at this stage. There are some procedure the court may direct the investigating officer or the concerned police station where the vehicle has been kept. That the photographs, etc., may be taken. There may be inventory in the form of inventory. Now at this stage, the inventory may not be prepared, but direction may be given by the court so that it can be released. But at this stage, your entire vehicle is a material exhibit. As per the report of the IO, I have not gone through the other records because there are what are the material exhibits, what are the MR, what are the other seizure list, etc. These are not before us.
Seizure list I have
No, seizure list of vehicle is already seizure. Seizure list and material exhibit, there are difference. Na? The last line you can see also, this is the material exhibit. This is the one aspect.
Under to your
And you
lordship,
will see to it.
your lordship, your lordship will see the altogether 19 witnesses are there. If the trial,
That's why I'm saying if any procedure can be, obtained by the learned trial court regarding release of the vehicle by taking all these things and secondary, if it can be, I'll make a reflection there. Inner my order itself. Now only. Part Mr. M. The learned part Mr. P. Bot. The learned additional PP appearing on behalf of state respondent. This is an application the section 528 BNSS against the impute order dated 29/01/2026 passed by learned sessions as Bongaigaon sessions case number 1/M of 2026, whereby the prayer for Jimma of the seized vehicle of the present petitioner was received. Expired is submitted by Mr. Khan that the present accused petitioner he was not arrested during the time of investigation. However, on the basis of a subsequent FIR, he got arrested, but at present he has not been forwarded and accused, and no cases pending against him at present. You are not forwarded, no?
No.
You are not forwarded.
No.
You are not forwarded as an accused. He is the registered owner of the vehicle, which has been seized in connection with this case. And since when it was seized? When it was seized?
seized the lordship on 28/9/2025.
Seized on 28/9/2025. Since then, the vehicle is in custody of the police, and hence there are every probability of damage of the car if it is kept further in open space. Also, the case has already been charged and after completion of the investigation, Mr. Khan further submitted that the charge sheet of this case was filed on 21/12/2025, and after filing of the charge sheet on 29/01/2026, 3/1/2026, a petition for Jimma was filed before the learned trial court below, and on file order dated 29/01/2026, the prayer for Jimma was rejected by the court. Mr. Khan further submitted, further relied on the decision of the Honorable Supreme Court, passed in case of Sundar Bhai Ambalal Desai, and the case of Biswadit Dey, Supra, which were reported by Swen. It is submitted by Mr. Khan that the present vehicle is nowhere the arrest office, and even if it is used for commission of the offense, but the case has already been charged, and thus there may not be any necessity for keeping the vehicle further in the police station. Keeping the registered owner of the vehicle, a Jimma may be granted in favor of the petition with any terms and conditions deemed fit and proper. Next, Mr. Bot submitted that the report of the IO seen that the entire crime, the murder of the deceased, was committed inside the vehicle, and the vehicle had already been sent for special examination. And special examination, and from the report itself, seen that the vehicle was directly used for commission of the offense, and it is a material exhibit. Also, from the report, it is further submitted that the relevant forensic examination and the evidentiary procedures have also been conducted during the evidence in the trial of this case. Mr. Potter accordingly raised the vehicle may not be released in Jimma at this stage, as it may be required for the purpose of at the time. Next one, during this submission, is record, annexures, there's the code of time which has been filed. It is an fact that the case has already been charged by on 21/12 and 20 in case state case is pending. And it is same also fact that after filing of the charge, a petition for Jimma was also moved before the learned trial court learned petition judge on 29/1/2026, but same was rejected by. It is also a fact that the case, the vehicle is in custody of police since long, and there is a probability of damage to the vehicle if it is kept further in police custody. But from the report of the police, it is seen that the entire vehicle is marked as material exhibit, and some forensic evidences are also related with the vehicle. And hence, I find it proper to direct the present petitioner to move an application, press application for Jimma for the learned trial court below, which will be the best court to judge as to whether the vehicle will be further required, which are stated to be the material exhibit in the case, and in the event if the petition is filed, whether any procedure can be adopted for release of the vehicle without comparing with the evidence of prosecution of the with of evidence of prosecution as it is stated to be the material exhibit by the investigating officer. With the above observation, the present Jimma petition is present so and so is hereby disposed of, with the direction to the petitioner to move press application for Jimma for the learned trial court bill, and an order will be passed accordingly, considering all the aspects of the case. I have reflected that any alternative mode can be adopted, then it can be. Stick right, buddy.
May please your lordship. In this case, I was convicted and sentenced under section 138 of the Negotiable Instrument Act. I was directed to pay a fine of rupees 10 lakhs. A sentence for 1 year, your lordship.
7 communication. 7 10 होने 7
Take 10 lakh?
No.
265 to?
7 communication.
দুখন এক the second to বেশি আছে your lordship may kindly peruse page 43
report with
page 43 paragraph 30 your lordship
report record. Yes, 43.
Page 43 paragraph 30 may I read your lordship in the result this is a negotiable instrument act case your lordship.
Yes.
In the result, it is concluded that the complainant Devasis Borbora has succeeded in establishing beyond reasonable doubt that the check bearing number so and so of rupees 8,86,000 was issued by the accused Rana Saha in discharge of his legally enforceable debt, and therefore the accused is convicted for the offence under section 138 Negotiable Instrument Act. Considering all aspects including the lapse of time from the issuance of the check, the accused Rana Saha is sentenced to undergo simple imprisonment for 1 year and also to pay a fine of rupees 10 lakhs to be paid as compensation to the complainant Devasis Borbora. Now, your lordship may kindly peruse. We have preferred an appeal. In an appeal, your lordship, on 13/10/2025, page 59, the order was passed by the learned additional session judge Udalguri. Your lordship, the operative portion is at page 63. May I read, your lordship? Paragraph 12.
Yes.
Therefore, in the light of section 148 Negotiable Instrument Act and judgment and cited herein above, appellant accused is directed to make payment of 10% of the compensation amount of rupees 10 lakhs. There is an amount of rupees 1 lakh within a period of 60 days from the date of passing of this order to date. Then, your lordship,
No, what is the order?
The order was to pay
The 10%.
10% was 1 lakh, your lordship.
Ah.
And I failed to pay, your lordship. I admit that I failed to pay that amount, your lordship, within the reasonable time, time, your lordship. And that is why this order, another order was passed by the learned session judge, your lordship. On 10/2/2025 at page 64. It's a long order, your lordship. I'm only on the relevant portion at page 73. May I read, your lordship? Paragraph 13. Considering the order dated 13/10/2025 when above prescriptions as made herein above, this court is of the view that on failure of the appellant to comply with order dated 13/10/2025 as per provision of 148 Negotiable Instrument Act, this court has to revoke the stay so granted by order dated 14/5/2025. In view of the above, for non-compliance and revocation of the stay so granted by this court, the appellant is directed to surrender before this court immediately, and his appeal shall be heard after taking the appellant into custody, who shall serve the sentence during the pendency of this appeal. This order was passed, the order case was fixed on 11/2/2026, informed learned counsel for both the parties, fixing 11/2/2026 for appearance and custody warrant. Now, your lordship, page 74. The next day, may I read the order, your lordship?
Yes.
So my stay was vacated. 11/2/2026. Appellant and respondent are represented by learned counsel. Today is fixed for appearance of the appellant in the light of order dated 10/2/2026. Appellant has not appeared in compliance of order dated 10/2/2026, and his learned counsel filed petition number 222/2026, paying to deposit the amount of rupees 1 lakh and further paying to condone the delay in payment, permitting appellant to deposit the interim amount, stating that no prejudice shall be caused to the respondent. Hence, for the interest of justice, learned counsel for the appellant has prayed to vacate order dated 10/2/2026 and to hear the appeal on merit. Also seen petition number 223/2026 filed by the learned counsel for the appellant, praying to dispense with the personal appearance of the appellant on the grounds that appellant is out of stature due to unavoidable and urgent personal work. His absence is to be willful, not willful and deliberate. An appellant shall appear on any date as fixed by this court. It is also stated that no prejudice will be caused by the respondent if personal appearance of the appellant is dispensed with. Heard both the sides of the petition, also peruse the case record. On perusal of both the petition, it appears to this court that the appellant has not complied with the direction of this court and has been playing tricks one after another, thereby violating this court's order, and in utter disobedience has filed petitions making mockery of justice. The appellant was directed to appear today, but another plea has been taken that he is out of station, and now learned counsel for the appellant has paid for disposing the interim compensation amount which was earlier ordered by order dated 13/10/2025. Such practice of the appellant cannot be accepted, and therefore both the petitions being number 222/2026 and 223/2026 are rejected. Issue non-bailable warrant of arrest against the appellant for non-compliance of order dated 10/2/2026, dealing extension of this court to do the needful, fixing 2/3/2026 for appearance report of NBWA and necessary order. I'm aggrieved by this order, your lordship. I admit the fact that I failed to deposit the money, and there are lapses on my part, and I apologize for that, your lordship. But your lordship, at this stage, I had the money. I'm ready to deposit the money. I'm only praying at this stage, your lordship, that the non-bailable warrant of arrest that has been issued against me may kindly be stayed, your lordship. I may be directed to appear before the court, and I'm ready to deposit the money, and the order I may be allowed to file a petition again, so that their particular order may kindly be considered. I'm ready to pay the money, your lordship. But because the non-bailable warrant of arrest is issued, so if I appear, your lordship, there is an apprehension and I will be taken into custody.
If he's willing to comply with the order, and apart from that, also,
I understand, your lordship, whatever the honorable judge has done, your lordship, true it is, I'm guilty on that regard, your lordship, but I'm only praying the non-bailable warrant of arrest may be kindly, lordship may see that
So
particular
you are
part.
agree with the order of this last order,
Last order, 11/2/2026, your lordship.
11?
11 to page 74.
in both the cases, 7 and 8, both are similar.
Both are similar, your lordship.
So both the cases is
In one case, I have to pay 1 lakh. The other case, I have to pay 2.5 lakhs, your lordship. That is 3.5 lakhs. It is a huge amount of money. It took me some time to arrange
now
the same money.
at present he is ready, also that part is maybe recorded.
So you are ready to pay your,
Yes, yes, your lordship.
ready to pay the money?
Yes, your lordship.
And
My
that
appeal may be
will-
heard, your
will
lordship,
be
that is all.
withdrawn,
Yes, your
and
lordship.
you may be allowed to contest the appeal on merit.
Exactly, your lordship. That is my only respectful submission, your lordship. It's a mercy petition, your lordship. It is not a petition, it's a mercy petition, your lordship.
Administrative duty and the petition, and also administrative. This is an application, section 528, for setting a certain portion of the impaired water. Five. Eleven to 26 is passed by additional section.
Yes, your lordship. Yes, your lordship. The other order, your lordship, is also passed by.
No, this is not passed by the learned magistrate.
No, your lordship.
You have
Because I have
appeared
prepared an
before-
appeal.
Acha.
I prepared an appeal, your lordship. I was convicted.
Yes, 11 to passed by learned additional session judge at Udalguri, ATR, in connection with criminal appeal number 13 of 2025, which the learned additional session judge Udalguri was pleased to issue non-bailable warrant of arrest against the present petition. Next one, submitted by Mr. Dude, present big and that he was initially convicted by learned court. Which court had convicted you? I'll initiate
Chief Judicial Magistrate Udalguri, your lordship.
CJM Udalguri, and sentenced to undergo 1 year along with compensation of rupees 10 lakhs, 10 lakhs, 10 lakhs in connection with NI case number 03/2024. And I think that order they have preferred an appeal before the learned section judge, which was numbered as criminal appeal number 13/2025, and the learned session judge accordingly asked the petitioner to deposit 10% of the compensation amount, which comes to rupees 1 lakh within stipulated time. But it is a fact that present petitioner could not appear for the could not deposit the money within time, and for which by its order dated. Next order your
10 to 2025, page 64, your lordship.
64, no?
Yes. That is the order. Your lordship, 11 to the next order, your lordship.
11 to is next order. Earlier order is
10 to 2026. The stay was vacated, your lordship.
yes, that's what. So and so. But as the petitioner could not furnish the could not deposit the amount of rupees 1 lakh, that is the 10% of the compensation amount, the learned court by its order dated 10 to 2026 had revoked the order of stay granted to the petitioner by order dated 14/05/2020, as he could not comply with the order, and the petitioner was directed to appear before the learned trial court below to serve with the sentences and to take him custody. After the said order, the petitioner again approached before the learned session judge on 11/2/2026. With a prayer to permit him to deposit rupees 1 lakh as the 10% of the compensation amount. But on the he could not be physically present, na?
No, your lordship. I
On that
filed a
also,
petition, your
he
lordship.
could not physically present for the learned additional session judge, and on his behalf, petition was filed by his and his counsel. but the learned appellate court had rejected the prayer and issued NBWA against the appellant for non-compliance with the order dated 10/2/2026. 10/2/2026. But at present, the learned but the present petitioner is ready to pay rupees 1 lakh towards the 10% of the compensation in pursuant to in under the provision of 148 and further paid for suspension of the NBWA for stay of the suspension of the NBWA issued against him, allowing the petitioner to contest the appeal appearing before the learned session judge. Next, Mr. Lawford, the learned petition be submitted in this regard. The petitioner is presently ready to deposit the amount. He may be given one more chance to contest the case, to contest the appeal by appearing before the learned additional session judge. Next, during the submission made by learned counsel, considering all aspects of the case, so considering submission made by learned counsel, that presently he is ready to pay rupees 1 lakh towards 10% of check amount. This court is obedient that petitioner may be given one more chance to contest the appeal by appealing before learned additional session judge and with a further direction to deposit rupees 1 lakh towards the 10% of the NBWA issued against the present petitioner may also be stayed till he appears before the previous stage. In view of above, the petition is hereby directed to deposit the said amount immediately before listing. Date of listing, can you tell
Yes,
us?
yes, definitely, Your Lordship.
Date of listing is when?
The 2/3, Your Lordship.
2/3.
Yes, Your Lordship. I can deposit before that.
Actually, for the learned torpedo and to learned appellate court and to deposit rupees 1 lakh towards 10% of the compensation as per provision of 148. The NBWA issued against which may be state with the above objection. In other case, what was the amount?
The amount is 2,50,000, Your Lordship.
What is it? Is it just 10%?
10%, the total compensation amount was 25 lakhs. I was supposed to pay 2,50,000. I failed, Your Lordship. Everything remains same, Your Lordship.
Date of
Date, order, everything same. There are two cases, Your Lordship.
except the criminal appeal number is different.
Except the criminal appeal. In this criminal appeal number is
Yes. The second case, the criminal appeal is
3, Your Lordship. Oh, no, not 3, Your Lordship. 12, Your Lordship.
12 of 2000?
25.
25 or 23? 25.
Criminal appeal number 25, Your Lordship. 12 of 25.
12 of 25 over. And can you tell us the NI case number?
NI case number is 3/2020 in this. I'm very grateful, Your Lordship.
My lord, this petition has been filed against the NBWA issued against the petitioner, my lord. Due to absence for few days, my lord, this NBWA has been issued. My lord, all along the petition.
Order sheets have you annexed?
My lord, I have annexed. That is page relevant portion of page 33. 33 is the order, my lord. My lord, all along the engaged counsel was taking steps for his non-appearance, my lord, showing cause. My lord, what happened, my lord? He is a daily laborer. He was working in Arunachal Pradesh, my lord. He could not come. But his engaged counsel all along was taking steps, and that was allowed by the learned trial court. And my lord, suddenly on 30/06/2025, that is page 31, my lord, the engaged counsel did not take any steps for his non-appearance, and accordingly, bailable warrant of arrest was issued rupees 1,000 against the petitioner, my lord, page 31. Last line,
Sorry, bailable warrant was issued.
lordship. And that was served on him on the day when the NBWA was issued. My lord, that is, my lord, kindly see page 33, para 3, lordship. He was not aware actually. My lord, para 3, my lord, seen the compliance report submitted by Laluk PS informing that BWS of rupees 1,000 issued against the said Bilal Hussain and Rashidul Islam. I am Rashidul Islam. Have been properly served as on 13/8/2025 and 25/9/2025 respectively. On the same day, my lord, I received the bailable warrant. Considering the above, led NBWA can be issued against the accused Bilal Hussain and Rashidul Islam. Now, my lord, I want to contest the case. I am ready to face the trial. Some protection may be granted, my lord. Next date is 23rd of March. Now he has come from Arunachal Pradesh. He is available at home, my lord.
Now to all will come. This is the big period when we was in district judiciary. This time everyone will come. All NBW are now will be executed. All. Election is there, so all will.
Otherwise, they would not come.
No. Now it is election.
Only election time, if any warrant is issued from to any person, then police is to police.
Then now they will all appear before the court. Maximum NBW will be now executed because of their presence. So they have now come from this election. And that's true. I have really trial court one, that's why.
But in my case, my, it was not delivered, my lord. I was compelled to compelled to stay in Arunachal Pradesh. I was working there, my lord.
Now why you have come now?
My lord, after coming home, my lord, this has come to knowledge of people. Some protection, my lord, I'll face the trial and I'll appear every day before court.
What's the condition? That's that he will pay. He will regularly appear.
You are Mr. H.R. Khan?
M. Ali.
Pardon, Mr. M. Ali. Yes, this is an application. PNSS implement order dated 509 passed by learned JMHS Sodipur EPRC case number 847 whereby non-bailable warrant of arrest has been issued against for his non-appearance. Next practice submitted by Mr. Ali that the present accused petition regularly appearing before the freedom and even his counsel, the steps was taken in case he could not appear well. But on 17/3/2025, he could not. I'm sorry, on 30/06/2025, he could not appear before the learned trial court below as he was working in Arunachal for his livelihood, and his counsel also did not take steps for him and or for his behalf, and for which the PWA available warrant of arrest was issued by the trial court below, which was not, and the petitioner was not aware about issuance of the bail. On the very next day, that is on 25/09/2025, it was held by the trial court below that bailable warrant has been executed on the petition and the day itself, and the said and the on that very day, the NBW was issued against for their wrongs. But the present petitioner is ready and willing to contest the case by appearing for the learned trial each and every day. the warrant of arrest issued against Mr. Hopper, it that he may be directed to appear before a unit with strict direction. During this submission, considering the order of conduct inspection, at the comma, he is directed to appear before a trial court which may be considered. When is next date is?
23rd of March.
However, till next date of listing, that is on 23/03/2026. The NBWA issued against him will be maybe state of Texas of observation.
Obliged, high level.
Make
Yes,
reason.
yes.
This is an application for quashing of a domestic violence case pending at Udalguri against the father-in-law and mother-in-law. What happened in this case? On 23/11/2023, my son get married with the respondent at Udalguri. My son get married with the respondent at Udalguri. Thereafter, due to some misunderstanding, my son filed a divorce case on 4/8/2025, which is pending.
In which court?
In the family court, Gauhati.
What?
After receiving the notice from the family court, they filed a domestic violence case on 9/10/2025 against my son and the petitioners, means the father-in-law and daughter, mother-in-law of the respondent. The complaint petition is Annexure 3 at page 20. My contention is that the allegations leveled against me, against the petitioner, means the father-in-law and the mother-in-law, are all general allegations. There is no specific allegation. May I read the relevant para? Page number 25. I'm reading para 8. That the conjugal life of the aggrieved party and the respondent number 1 was passing peacefully for about 5 months. Thereafter, trouble started in the conjugal life of the aggrieved party and the respondent number 1. Respondent 1 is the son. Initially, the aggrieved person witnessed huge fights among the respondents itself over some past illicit relationship of the respondent 1, which was new and shocking to the aggrieved person. As because the respondent number 2 and 3, during their fight with the respondent 1, used to disclose some questionable details out of anger about the illicit relationship of the respondent 1. Next, the allegation is in para 10 that the respondent number 1, on ill advice of the respondent number 2 and 3, used to torture the aggrieved person and used to humiliate the aggrieved person in every possible way. The respondent, having a keen interest on the only property of the father of the aggrieved person, situated at village Kalita Kushi under Beltala Moja, Kamrup. Since the respondent themselves have a flat in Gauhati, which is their permanent resident, so and so, the respondent 1, for his future prospect, wants to plot the land to extend his residence. Thereafter, on the last 3 lines, the respondent 3 on many occasions used to push the aggrieved person while working in the kitchen, did not allow her to wear her jewelry, which she bought from her parents' house, and treated her like a servant and deprived the aggrieved person for her basic needs. The next allegation is in para 11. On last 5/9/2024, the respondent number 2, means the father-in-law, call the parents of the aggrieved person and inform that the aggrieved person has applied for district recruitment Assam government examination, which was scheduled to be held on 29/9/2024, and threatened the parents of the aggrieved person not to encourage her aggrieved person again to apply for such examination. And the last
There are some specific allegation against you. Not, it is not a case that all the allegations are general and vague, but there are some specific.
Then the allegations are
This way you are harassing her.
no.
This conduct shows that you are harassing her.
No, my lord. Initially, she was residing with us. Thereafter, she shifted to Bangalore with my son. And they were residing in Bangalore. From their complaint petition, it can be inferred. They are residing at Bangalore. Para 15. Aggrieved person, respondent number 1, shifted to Bangalore and they started living in a rented house. They are living in the rented house in the Bangalore. My contention is that the allegations in para 10, that ill advice of the respondent, the son is harassing, which is a general allegation. Moreover, that the father-in-law father-in-law threatened the parents of the aggrieved person not to apply for examination. This is a general allegation.
How general allegation?
We have not, because it does not cover the domestic violence.
She is staying with you when you are harassing mentally. That you don't do this, don't wear jewelry, don't put the work in. Why it will not come under domestic violence? Well,
This
she
is a
was
false
with
allegation.
you in that time only. You are harassing her mentally. That you cannot appear this kind of examination. You cannot go out. You cannot wear jewelry. So all these are there.
She is saying that I am telephone her father, that she cannot appear. In fact, she is working. In fact, she is working in the post. They themselves admitted. She is working and in that school. So see, all are general allegations. And we are interested in their property. The allegation is that the respondent is having a keen interest on their property. We are not interested in their property.
Divakar Purva.
He is my son. So there is allegation against the son. I am not disputing on that. Because we are residing at Gauhati in our house. And they are residing at Bangalore. So the allegation against the son, we have no, but there is no allegation, specific allegation against us. So they are trying to rope all the family members in the domestic violence.
You're Mr. M. Cobra?
A couple.
Mr. A. Cobra. Why PPJ? You are not the party. Not even a formal party. Is it? No. Not the formal party also.
Lordship.
See, you are not the formal party also. No? He states the party here.
Party we are here, Lordship, but we are forming as
The party. Yeah, our petition, you are not the party. Oh, sorry. Sorry. I have seen it. Yes, you are the formal party. Yes. Also heard Mr. Yes, Crawford, Ilan petition PP application for quashing TB case number 4 of it. Planet CGM against the present petitioner number 1. Issue notice to the respondents to speed post and Mobile notice is required to be served. Stated for number 1. So called for the scan copy of the PC. Further considering the submission made by Mr. The petition number 1 and 2 were the who stated to be the father-in-law and mother-in-law of the respondent number 2. Case, the DB case pending against pending DB case number 34 of 2025. And before the learned court below, the state in respect of petition number 1 and 2 were stated to be the father-in-law and mother-in-law respectively for the till next is the matter accordingly as admitted to be
Till the intermediate, the proceeding may be stayed.
staged.
Make this your lordship.
Yes.
Lordship, 528 application. 528 application. I preferred this petition to question FIR dated 4/2/2026. Registered at Dispur PS 66.
FIR or
Yes,
case?
FIR. Question of
FIR.
FIR. Yes,
FIR
lordship.
and
Quashing of
subsequent
FIR.
proceeding, lordship.
Yes, FIR and subsequent proceeding, lordship.
Subsequent
so-
proceeding means the case is already charged sheet?
Charge sheet.
Oh, acha, acha. Okay.
Lordship, so FIR, type copy FIR is in page 10.
Page
And
10.
translated copies in page 14 and 16, lordship. It's not attached, but I brought it later. Page 10 is the FIR type copy. May I read the FIR, lordship? The complainant so-and-so lodged an FIR dispute PS stating that she met the accused Rahul Jimma about 2 years ago. He allegedly induced her with false promise of marriage and established physical relation with her on multiple occasions, including on 8/12/2025 at a hotel after bringing her from Jaipur. Subsequently, they married on 28/1/2026 as per government rules and stayed in a hotel thereafter. Post-marriage, the accused allegedly subjected her to physical assault, criminal intimidation, and demanded 10 lakhs, diamond rings, gold chains, and expensive car. He was allegedly threatened to kill her. He also allegedly threatened to kill her and sell her in Haryana, and also threatened her by placing a rope around her neck in the hotel. Hence the case. Lordship, page number 14 and 15 is a translated copy, the same FIR. Lordship, the crux of the matter here is that the accused petitioner used to live in Africa. And 2 years back, they were through contact from the relatives they met, and they were in touch. And the petitioner, the complainant here asks for the petitioner the relevant required documents for the court marriage. And he sent all the original documents and the court marriage, all the filing, all the registry was done, and the petitioner traveled from Africa to Gauhati in the month of January. And the marriage took place in the register of marriage in this Hangrabari DC office, which the marriage certificate, you will find it in page number 22.
When the marriage took place?
Marriage took place on 28, this last month, January 28th,
19th of January.
2026. Yes, Lordship. Thereafter, after 6th day, the complainant lodged an FIR against me, which the FIR is in page number. After the 6th day of the marriage, she lodged an FIR.
That has already been reflected in the FIR itself.
Yes, Lordship. Lordship, the thing is that after the marriage, the complainant and her uncle kept me in a confinement, illegal confinement, seizing all my documents in a hotel in Ganeshpuri. And rather, upon finding that she is already married, photography I have annexed, which is in page number 23 to 26. She was already married, previous marriage. And surprisingly, the marriage that was held last year, December, which in my petition, page number Paragraph 8. She was married to Mr. Pawan, last line, Mr. Pawan Kumar from Jaipur. She was already married, and ceremonial marriage was conducted, which was done, dated marriage of the dead was 11/12/2025.
Under
And she
which
has
case-
concealed her
under which
marriage.
Section now case is registered against
Yes,
you?
yes. Thereafter, again, this lady the complainant went to a Mahila police station and lodged a complaint against me. And upon calling the accused and the accused petitioner and the complainant, they find the Mahila police, the officer in charge, find inconsistency in the statement of the complainant and her uncle. And and the petitioner here was advised to lodge an FIR against the complainant here in this case, Lordship. And thereafter, FIR was lodged, FIR was lodged, which is in page number.
But the case is already charged against you now.
No, not charge sheet.
Not yet charged.
Yes, Lordship.
Why it is before SDGM?
Yes, this is completely Lord.
Metro.
Page number 34, cross of fire, you'll find in page number 34 to 41.
This FIR is lodged by you.
Yes, cross FIR was lodged for concealing the previous marriage and filing a false FIR against me for keeping me in illegal confinement and seizing my documents, Lordship. It's quite lengthy. If Lordship will please, I will read out.
So now it is this case the lodged against you is still under
Yes,
investigation.
yes, Lordship, I have taken a
Here it says-
permission from the court to
Certificate
seek a
of file,
jurisdiction.
Lordship. The last order is for that he was supposed to travel to some other places.
Yes, permission was taken
For
to go to
permission,
Pakistan.
for seeking permission, he filed this petition. And she has probably not submitted.
sought permission to
Travel
return back to
outside
Africa.
jurisdiction.
Probably
Yes.
that may be a condition for bail. taking.
Yes, bail condition.
Maybe.
He is on bail now.
Yes, he's on bail. He already applied for the bail.
Now you are for quashing of the affair.
Yes, Lordship.
Not the subsequent proceeding. He still
Subsequent
says
proceeding, but
subsequent
a charge sheet is
proceeding, I
not
thought
yet filed, Lordship.
Huh?
Charge sheet is not done yet.
not yet filed.
Yet,
no.
yet
Still
not
under
yet filed.
investigation.
Yes, still under
But
investigation.
police found that there are some inconsistency.
Upon this complainant, the
Complainant and
statement,
their
upon the statement,
statements.
yes, and the petitioner was advised to
So,
file a cross
what is the
FIR.
problem? They may file FR also. Yes, Borhe.
But,
This still, Lordship, I think I stay the proceeding because, Lordship, as he is already on bail, Lordship. And
Stay the proceeding is under investigation. Is it under investigation? Isn't
he
it?
is under investigation.
Case is not, charge sheet is not filed, so investigation generally we do not pass any stay order.
Lordship, may
if-
initially the Dispur FIR, the Dispur police was denying to lodge an FIR. The IO
Whatever, now
was,
the FIR has been
yes, yes.
I
Upon,
mean, accepted.
yes, Lordship, upon
And,
the
case-
instruction of the SCP of the Mahila police, they lodge a cross FIR.
Whatever it is,
Cross
two
FIR is
affairs are
lodged
there,
by
Lordship.
you.
One is
Yes.
filed
And
by
it's
this
a
person,
bygone
another is
offense.
filed by that side, Lordship. Probably there is a case, case is made out, Lordship. At this stage, Lordship may kindly call for a CD so that we can,
So
Lordship,
the case that you are on bail, you do not hamper.
Lordship, in order to shield herself and not to take responsibility, she has lodged a false allegation. The photo
I
is
can
there.
understand.
This is the previous.
The false allegation is brought against you
Yes,
after
Lordship.
6 or 7 days of her marriage,
Yes, Lordship.
as you have submitted, and that we after concealing her earlier marriage
Yes.
and for his illegal conference, you have also lodged a cross case against her. That is understood. That is also on the pending. Now we are going to call for the case diary. Let us see what is the progress of the case and whether there is any material as you submitted that there are inconsistency in the statement recorded and the complaint itself. There may be. So if prima facie there is no case at all, that may be a case for quashing. But without appraisal of the case diary and order, we cannot pass the order. Okay.
Okay, Lordship. Oblige.
Your good name?
Otoli Kids.
Arts and yes, totally kids. Return it.
Lordship, both the CDs of both the case.
Can you call for both the so that Lordship can, it will be good for us.
What is the other case? You just have to tell us. Anyway, this is
Disperse 80. That
uh,
is disperse 80.
violation of 58 BNSS for quashing of the FI dated 0066 of 2026. Filed on 4/2026 before this would be under section 109, 1152, 3513, 35 subsection 3, 85 of BNSS.
Yes, case number.
BNSS. BNSS post.
Which one case number?
Next one.
Below
To
86 of 2026.
notice to the response, no following of this is required to be submitted. Further considering this submission, we try to also propose that the case report is for PS case number 0066 of 2026. Filed on 4/2/2026, and your case number, your case number
Disperse 80 oblique 2026.
80 oblique 2026. 2026. That is also government police station. Before all
No,
of
Disperse police station.
this
Since the Mahila could not arrest Mahila, the lady, she was instructed to go.
Your case is also pending before Dispur.
Yes, Lordship.
Dispur police station case number 80 oblique 2020.
But in my case, she was released on personal bond from the police station.
You are also on bail.
But I went to the court. I went to the court and get the bail, but against her,
What
she
to do?
got a bail from the
How
police
the
station.
other cases
So, yes.
On
considered
23rd
by-
March, Lordship.
Pardon?
On 23rd March.
23rd of March.
Right.
You'll be able to come on 23rd of March.
Yes, Lordship.
We're calling you.
Grateful, Lordship.
Yes. What is 17?
17.
We have received here, is there?
My lord. In this case, charge sheet submitted.
You are in custody since when?
Lordship, I am in interim,
Oh, you are on interim.
on 4/2/2016, 26.
Since
Biswajit
4/2026, you are on interim.
Yes, Lord.
Heard Mr. A. Sharma, the learned counsel for the petition. Also heard Mr. P. Botwood, the learned additional deputy appearing on behalf of state response. It was speaker for case diary, but it is submitted by Mr. Botwood. That case has already been transited. By CS number, yes.
CS number 52/26 dated 24/2/26.
Then what do we will make regular or what?
My lord, let him appear before the trial court for opening, my lord. He will have to submit bond.
Of this.
Lordship, other co-accused was already released on bail by the learned trial court.
You are already on interim,
Yes.
so you can appear before the learned your may be absolute. In view of this, the interim bail granted to the present petitioner dated 4/2/2026 be extended for 15 days will do.
Interim bail, yes, Lord.
15 days we are extending your
Yes, Lord.
15 days, enabling the petitioner to appear before learned trial court below with an appropriate application form or to make the bail absolute.
My prayer before Lordship, my lord. Your Lordship may also call for the scan copy of the, my lord,
Okay.
TCR, my lord, because regarding forging of some domicile certificate, my lord, forging of some document is also there. So scan copy of TCR may be called for.
Yeah, introduce the scan copy. Interim be extended till next date of listing. When it can be, rest you will do the input.
On 24th of March.
You are extending your interim.
Lordship. Alia,
Yes, what is the office note here, Mr. Botaku?
Yes, case diary received, my lord, in all these cases, my lord, here, two persons, my lord, in item number in jail, otherwise all other persons are in, accused persons are in interim, on the ground that they are appearing in, my lord, SS second year examination, and on that point of time, interim granted to some of the accused persons, my lord. They were student, otherwise, my lord, one, they in fact brutally assaulted one.
My lord, before my friend goes into the merit of the case, can it be like this, my lord? Because, my lord, the petitioners who are on interim bail, their final exam, for some, the final exam will be over on 12th of March, and for some, the final exam will be over on 9th of March. So, can this matter, the candidates who are on interim, can their bail application be heard after 12th of March? And my friend says his client is behind the bar and is supposed to appear in an exam on 5th of March. So his bail application may be taken up today either for interim or for absolute, subject to what he submits. As far as item number 19, 20 and 25, these are the three bail
19,
applications.
20, 21. 21. You all are on interim.
Interim. And the exams are still continuing. And the last date is on 12th of March. That is economics. So these bail application may be taken up any date after 12th of March.
Item number,
Item number 19, 20, 21, 25.
21 and 25 is also there.
Yes.
Yes.
19,
19, 20 ular.
19, 21 again,
19,
20,
19, 20, 21, 25.
Or 25. এইটা আপনি 12 তারিখের ভিতরে ওনার একটা কনভিনিয়েন্ট ডেট করুন
19, 20, 21,
25, my lordship.
19, Mr. You are appearing. And 20, Mr. Biswas is appearing. 21, who is appearing? DJ Boro is appearing. And 25 also, Biswas is appearing.
Absolutely.
You all are in
Candidates, all are candidates.
19, 20, 21, and 25. The Daniel Council and respective Daniel Councils appearing for all the petitions. And also had Mr. P. Bort put the Daniel petition PP appearing on behalf of CTDC, but considering the submission made by Daniel Council for the petitions, that the examination of these accused persons are still going on, and it may be over by 9/3/2026, and some of the petitioner examination will be over by 12/3/2026. Considering this, that all the matters be listed when it.
my lord, because CD is, my lord, pending here since long. Your lordship may kindly fix it on 17th or 16th.
Your Honor, I have one pair 16 and 17. I have a matter fixed at 0 court. 16, 17 residing any date.
My lord, except her matter, my lord, other matters can be taken up. My lord.
Again, it will be a problem.
Oh yes, on 18th of March, my lord. 18th of March.
Obliged to.
The interim may continue in all those.
Interim may continue. The two factor evacuated here, so CDB return for updation. Interim be continued.
I'm deeply obliged.
Yes,
Highly
Mr.
obliged.
Purva, your case.
My lord, my item number is 18, my lord. My examination is, my lord, scheduled to be held from, my lord, 5th of March, my lord. And as on date, my lord, I am in, my lord, 57 days in custody, my lord, except
No, no, he's not written now. It will again. Okay,
18, my lord. And, my lord, except the petitioner. Ricky Bora is the petitioner here, my lord.
Who is?
Ricky Bora, my lord. Rishi Bora.
Rishi Borua, my lord.
Rishi Borua, my lord. Item number 18. I was arrested on, my lord, 1/1/2026, my lord, and as on date, my lord, 57 days in custody, my lord. And my lord, examination, my lord, scheduled to be held from my lord, 5th of March, my lord. In the additional affidavit, I have, my lord, annexed my examination schedule, my lord. And except the petitioner, my lord, all the other rest of the petitioner in other cases, my lord, they were considering their, my lord, ground of, my lord, examination, my lord, they were, my lord, allowed to, my lord, release an interim bail, my lord. 5th of March. Next Thursday, my lord.
You got your admit card or not?
Yes, my lord. I got my admit card, my lord. But at the filing of this application, my lord, it was not issued, my lord, but subsequently it was issued, my lord. I have a copy, my lord.
Just give us the copy.
So far, schedule is concerned, my lord, in the additional affidavit, I have already annexed, my lord. And my examination will be, my lord, finished on, my lord, 26/3/2026. And as on that, my lord, already 57.
Reliance Senior Secondary. Circuit House Road. Is it the original?
No, my lord, it's a
It's a bit different thing. Believe it or not,
it's his first year examination, my lord. This admit card has been issued by college, my lord, not from my lord board, my lord.
for HS first year.
Lordship, my lord. It's his first year final examination, my lord. This issuing by college, my lord. And as of date, my lord, 57 days in custody.
But Mr. K. Borua, Lilanet Council petition. So speak to Lilanet petition. Everyone.
Already 7 were submitted by
The this daily visit, considering the submission made by petition. Let the updated case diary be called for in connection with this case. Further, considering the further it is submitted to Mr. Boru that the present petitioner is a high secondary first year student and his examination is scheduled to be held from 5/3/2026. And the time routine and timetable etc. is also furnished along with through an additional affidavit. Further is produced the admit card issued in favor of the present petitioner who is going to appear as secondary first year examination. Further, some accused petitioner was arrested based on this suspicion and since 1/1/2026 he is in custody. So all the other four accused persons are already returned in interim bail for considering their ensuing examination. Considering the present case of the present petitioner, same thing. The prayer for present petitioner of interim bail may also be considered. However, he is ready to extend his cooperation in the further investigation of this case. He is allowed to retain previous bail. The portable Iran election committed that one person is brutally killed by the group of persons. The incident happened only on 31/2025 and case is still under investigation. Accordingly, he submitted a criminal be considered at this stage.
Last 12.
Bail application number 3/3/2026 dated 9/2. Last prayer same দিব খালি আপোনাৰ এইটো 11 February আছে সেইটো আপোনাৰ 5th of March and it is final higher secondary examination detail HS first year. Okay, will be under interim protection. Same date will be there on 18/3. Updation for CTP detail for updation.
Yes. Oh, itu আমার friend. 26.
No, not 20.
20, same PS.
Same city.
No, my lord, same PS case, my lord. With Nigamko part.
May I please your lordship?
Yes.
Lordship, here while filing the bail application, the exam schedule of the petitioner was not released, but thereafter exam schedule has been released, which I have filed yesterday by way of an additional affidavit, lordship. Lordship, exams are commencing from 17th of March, but petitioner's respective subjects will be commencing from 21st March, lordship.
His back examination or what?
No, lordship.
He is studying in which
Lordship,
senior
lordship, class 12, lordship.
class 12.
Senior secondary final examination, lordship. Lordship, page 42 annexure 9 of the additional affidavit, lordship.
This is open school.
Yes, lordship.
Very nice.
Due to
open school.
financial
Can be-
constraints,
can be-
lordship,
huh?
due to financial constraints, he is pursuing through his open schooling.
That can be, but
Yes.
if he is a student of open school, then he can appear through this from the jail premises. It's jail from jail.
No, lordship. Mode of examination is same. Only the thing is difference is open schooling, but mode of examination even everything is same. Lordship.
How same means? He has to appear physically.
Yes, lordship. Even in the admit also below routine it has been mentioned, lordship. Mode of examination will be same, lordship. And another one accused petitioner of the same case, lordship, who is also of the same class 12, who is also appearing for the same examination. He's behind the bars. He has been also granted interim protection by the Honorable District and Session Judge Golaghat yesterday. And I have also the order, lordship.
If they are all are their students,
Yes.
how can they commit such kind of offense?
Yes. They are enjoying party in a birthday party in the house of one
Very
Ankur
birthday
Jyoti
party.
Sharma, my lord.
Alcohol and all
And
everything they
thereafter,
were enjoying.
Yes.
The person whom is alleged to have been killed by them was the neighbor also.
Yes.
Neighbor.
Yes.
Huh.
They are the
They
one
just
that
came-
they actually came to attack one of their friends who stayed in the neighbor of the deceased person. my lord. They actually went outside only to save those
Yes.
victims. And thereafter they brutally attacked all
Class
the
12, class higher secondary students are there. All are there.
yes.
All about most probably 18, 19, 20 years of age. And they are doing these things.
From their birthday party, first one phone call, because someone's my lord, one ex-girlfriend is now my lord, girlfriend of someone of that party, my lord. Thereafter, my lord, threatening one of the my lord victim. Thereafter, all those initially 4 comes, my lord. Outside their house, they created some request there, and thereafter, my lord, call them out of their house, and thereafter brutally assaulted. Then neighboring people came there to my lord save them, and thereafter, my lord, a group of 20 again, my lord, after 5 minutes, 20 students come there, my lord, from their birthday party, and thereafter brutally assaulted that victim. This is one Meganko Hazarika and other, my lord, injured.
So, lordship, in this case, I also pray for protection of the petitioner for only for appearing in the examination, lordship. Till his examinations are over, lordship.
Your examination is going to commence on 21st of March. Prior to that, the matter may be heard and decided also.
Lordship, that is there, but
All are in the
You are,
interim- all are already in getting interim protection, so let him also well go, otherwise.
বাকি কেনেকে থাকিব খালি এইটো 21st of March to 24th of March. That's it. এইটো হ'ব through National Institute of Open School, which is scheduled to be held from 21st of March to March 26th. And then 28th. Wait, okay.
Much obliged, Lordship. Wait, please, your Lordship.
Yeah, office note, I think.
My lord, office note, my lord, scan copy was called for, my lord. Scan copy of
Not
here,
received.
not my lord.
My lord, I'm in judicial custody since 64 days. Forwarding.
No, the 64 days is okay. It's a charge sheeted case. I
My
think.
lord, sir.
Actually, yes,
Under which section it has been charged?
69 BLS.
69.
69.
Repeat false promise.
My lord, Kallisi,
No, it's okay. We are not
My lord.
taking because one court had
This year
already
not.
passed the order calling for the scan copy. It has to come from.
My-
We are giving you a short date, right?
My lord.
You're Mr. Rahman.
yes.
Heard Mr. M. Rahman, the land counsel for the petition. Also heard Mr. P. Sharma, so and so. As per office note, is seen that the scan copy of the TCR with the case diary is not yet received by the concerned section. Issue reminder directing the learned trial court below.
1 week 10.
Huh?
1 week 10 mechanism.
Huh?
Not more than 1 week 10 method.
Learned trial court below is hereby directed furnish the case diary on or scan copy of the case record along with the case diary on or before positively on or before the next date of listing. List the matter accordingly.
10th of March, my lord.
Okay, then on 10th will do. 10th of March.
It will be too long, man.
Huh?
It will be too long, Lordship.
No,
Within
we
a
don't
very
need a short date rather. Then in that case to at best on 9th of March. Not more than.
My lord, 9 or 10.
Man,
9.
You filed one affidavit here, no? We have received it.
yes. As on date, 54 days in custody and victim has been recovered. Her statement has been recorded,
It is charge sheeted case or not yet charged?
not yet substituted. Now, Lordship, kindly.
What you are submitting through additional affidavit?
Yes, additional submitted, basically the judgment of the DK Bosu case and Bihan Kumar as well as the Mehbubul Haq. 3 judgment relates to the violation of section 36 is apparent on the face of the the
Now, where from you are saying the girl recovered?
yes.
Where from?
Yes.
Now, these are okay. Where from you are saying the girl recovered?
Order is that we will get it. Let it be taken at 2 minutes. We'll produce the
Yeah, we have
order.
not received case there also.
Let it be at
No,
2
case
minutes.
diary not received. He is saying that girl is recovered.
Yes,
Mine.
recovered.
That is main.
Mine.
Yes,
we
we will
want
produce
to-
the order at 2 minutes. Let it be at 2 minutes. Yes. Order to do three.
Item number 15. In this, we have been, one side, item 1. Not allowed to give a reply, but for some or the other reason, I know is not perfectly proactive. So we could not file reply. So I seek for 1 week. I have informed Mr. Gauhati morning in the morning he was here.
He's facing hard for that, but he's not requesting for full. The morning he was because I had some other matters. It may be somewhere after only 6 or 7. Because there are again 2 in there. I will. I have already put a word to him that this is the position. Okay. Okay. Now we'll wait for. Okay.
Yes, my lord. We have got the my lord order. ঠিক আছে এইটু দিয়ে একটু সাইড দিয়ে এই যে সাথে একটু দিলে লেখানো হয় না my lord order dated 3/1/2026
3/1/26.
yes lordship will find
In which para?
my lord internal page formula. Now, regarding the Jimma of the victim, a petition is furnished by the mother of the victim praying for the custody of the victim. Prayer is allowed. The mother is directed to furnish a bond of rupees 5,000 to the satisfaction of the court with a condition that she will produce her daughter as and whenever required by the court. Later on, bond of rupees 5,000 is furnished by the victim's mother, which is seen, verified and accepted. IO is directed to escort the victim along with a lady constable to their safe destiny. Send the case record so and so. Now another order lordship will find same day on 3/1/2026. It says smaller later on, the IO has produced the victim of this instant case with a prayer for recording the statement of the victim under section 183 BNSS. Peruse the case record, prayer is allowed. Landed so and so shall record the statement of the victim. So discover.
Which order you reading?
Muller. This also Muller 3/1/2026.
3/1/26.
In continuation, Muller, later on.
Later on.
Yes. So since victim has been recovered and her statement has been recorded and she has been given custody to her mother, but considering the detention period as on date 54 days is in custody, my lord. Yes.
It is connection with this case only?
Yes. Now, apart from the my lord, violation of section 36 of the BNSS, my lord, we have filed my lord, additional affidavit being on record. In any case, since she has been recovered, my lord, she is in safe custody with her mother.
36 is not complied with?
Yes, not complied with.
Where from you are saying?
Yes, my lord, we have
Annexed?
we have annexed the my lord, page 22 lordship will find. Yes. My lord, 36 says, my lord, prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or respectable member of the locality where the arrest is made. Now, lordship, kindly see page 22. No such endorsements of the family member or people of the said locality. Page 22.
He hails from where?
He is from Mankasar.
And he got arrested where?
There, Mankasar.
In Mankasar itself?
Mankasar itself.
Yes.
My lord, here, first of all, my lord, we have here present, my lord, and whether any section edit after her recovery, whether as from the FI, because he was 15 years old at the time of my lord, kidnapping. Then whether after recovery, my lord, where POCSO is added or any section added, that something that is witnessed.
Oh, this is not there.
My lord. And regarding the 36, my lord, although my lord, my colleague submitted, my lord, I would like to call for CD, my lord. And after period of the we have accepted, we have anyone.
We have given the
Basically,
certified.
there may be some sections may be edit manner. If we have recovered after some several days, then providing my last was stated the hard water was to Tamil Nadu. It was taken to Tamil Nadu.
This is. He has been recovered, her statement has been recorded, she has been given to Jimma, to her mother.
No, as per application, he is saying.
Yes, my lord.
For our investigation, my lord, facility. For that may be given my lord, the next week from. Yeah.
Yes, from Romania.
Yes. My lord, she is from Rongia because she, my lord, used to my lord, practice YouTuber with the my lord, accused person. They, along with my lord, make some program.
To say. He is, she is Armina Parvin, na?
My lord. Yes.
Is hardly 15 years.
My lord.
As per your submission.
Yes. Now she is my lord, 17 years as per the my lord. We have my lord annexed the on my lord, Aadhaar card.
No. Your additional
Aadhaar card, my lord.
Yes.
My lord.
Your additional affidavit carries one document. Your additional.
Additional affidavit, my lord, carry two documents, my lord. One is my lord, arrest memo under section 3.
No, it's okay. One this. What is Aadhaar card?
Next, Aadhaar card.
And from Aadhaar card, what you are saying? From Aadhaar card, she's
Aadhaar card,
17
my lord,
years.
she's date of birth is my lord 2/1/2010.
Then you try. If 2/1/2010 also it is 20. In that case
2000.
also she's not.
Yes.
Then also 15 years, my lord. It's 25.
From your document.
In any case, my lord, in view of the DK Bosu judgment and my lord, the Bihan Kumar and my lord, Mehbul Haq of our high courts, my lord, in view of section 36 and 47 and 48.
I have NXG 47, 48 also here.
Yes. Not an external.
Not
Judgment
annexed
kita
here.
dia. Judgment kita dia.
See, sometimes it happens. I don't know. In one case, I have dealt it.
Yes.
Therein, is this signature of the family members were not there.
Yes.
But there's through this mode, other mode, the case was filed and this obtained.
47, 48.
For that reason, we cannot say at this stage whether there is what the compliance of Sick intention is that his her family members, his or her family members should be informed. But if it is done already, there may be sufficient compliance. I don't know at this stage. We cannot say.
Yes. Now, in any case, my lord, investigation has been completed because victim has been recovered.
No, what the sections added? If there are any sections is
Till date, my lord, today is we have obtained the certified copy, my lord, today itself. In the certified copy, no such section is added.
Order is earlier, that is January.
3/1/2026.
Earlier order.
Earlier order.
3/1/2026. 3/1/2026.
3/1/2026.
On
When her
the date of
statement was
arrest,
recorded.
the date of arrest.
And certified copy was obtained today.
The petitioner also arrested on
Today is
3/1.
okay, huh?
3/1. Arrested on 3/1/20. And the order is also on the 3/1/20. Later on, there will
You
be
just
some.
personally inform the IO to forensic case diary.
My lord.
Heard Mr. M. Mandal, the direct counsel for the petition. One additional affidavit is also filed by petition. And Mr. P. Sharma, P. Sharma. How it is submitted. That he did not visit, and at this juncture it is not possible on his part to submit on merit of the case, as there is probability of adding other sections of POCSO also. It is submitted the result of the case that is necessary for passing any order. However, Mr. Mondal submitted this record that the girl has already been petitioned. And at that part there is no compliance of section 36 of BNSS, which has also been annexed. In view of this, let the CDP call for the IO with a issuing reminder and direct a further direction to furnish the case diary on or before the next date of listing. List accordingly when it can be listed. Second March. We are giving very short date. This week only tomorrow is the date. I don't have any dates. Second is.
Can it be on tomorrow, my lord?
Then again it will be listed in the month of March 15, 16. If you insist on.
24.
Monday.
Late is a lordship.
Yes.
My lord, FI is at page 19.
Yes, what is the position here?
Page
Page 19.
19, my lord. Date of information 1/12/2025. After
Yes.
6 months, the incident happened on
Date of information is?
1/12/2025, page 19, right-hand side top.
Hmm.
And date of incident 7/6/25 in the FI. And below it is written, চিকিৎসা আর মৃতকর সংখ্যার কামত ব্যস্ত থাকার ভাবে এজাহার দিয়ার প্রলম্বন. That explanation is given.
Yes, what is the FIR about?
Page 19, ma'am.
Yes.
সন্মান সহকারে আপোনাক জনোৱা যায় যে ইমান তাৰিখে ৰাতি প্ৰায় 7:30 মান বজাত মোৰ ল'ৰা চাৰ্জ ইমান বয়স পিতা সৰ্গীয় স্বাধীন তাজ ঘৰৰ পিছত তেওঁৰ বন্ধু মুজিবৰ হুছেইন পিতা ইমান পৰা ঘৰলৈ আহি থকাৰ অৱস্থাত ৰাজধানী চহৰ আগৰ পৰা পৰিকৃতভাৱে উক্ত পদকে গণে ৰাস্তাৰ ওপৰত এখন বেঞ্চ পাতি আগৰি ধৰে আলো দলমধ্য কথা মহম্মদৰে কোবাই মাৰপিট কৰে, যাৰ ফলত মোৰ ল'ৰাজন মূৰত গুৰুতৰ জখম হয় আৰু মাটিত পৰি যায়। লগতে তেওঁৰ বন্ধু আঘাতপ্ৰাপ্ত হয় আৰু মটৰচাইকেলত ক্ষতিসাধন হয়। লগে মই জানিব পাৰি উক্ত উপস্থিত হওঁ আৰু মোৰ ল'ৰাজনৰ লগত বন্ধুজনক যোৰহাট লাইফ ছেভ হস্পিটেলত চিকিৎসাৰ বাবে লওঁ। তাৰপিছত উক্ত চিকিৎসাৰ বাবে 18-16-25 তাৰিখে দিনা প্ৰায় 4 মান বজাত গুৱাহাটী GMC চিকিৎসাৰ বাবে ভৰ্তি কৰা। যদি যোৱা ইংৰাজী ইমান তাৰিখে 24/6/25 তাৰিখে প্ৰায় 1 মান বজাত ডক্টৰ মোৰ ল'ৰাজনক মৃত বুলি ঘোষণা কৰে। So 24/6/25 death occurred, incident, and the FIR lost 11/12/2025. I was arrested on 30/12/2025, 58 days. 47 notice is there, page 33. And 48 notice is there at page 36. Okay, notice. 48 notice. That is more.
Hello.
Yes. Now your plea, you're not,
I'm not, my lord, not guilty. That is my regular plea. And my lord, after 6 months, you're now 58 days, around 2 months, I am in custody. Is there any more custodial interrogation is required? That much your lordship has to decide that.
yes.
Here, within the treasury matter, is a but but I one bench put by month. They take one bench put
Bench, bench.
bench. After I one person died. The rider is survived somehow survived. His statement is there. They will put registered under 105 billion. Here 2% is volume. This intentional knowledge. The party. The the intention from causing some harm to the previous matter. That's why they have found the matter against the fine for by to the children. And knowing the matter after children they have yes party.
Your lordship may just look into who the person, there are 3-4 persons who has assaulted. That part your lordship has to look into. Because in the FIR, I find there are few names are there. There are 4 persons' name. I am one of them. Okay. One of them.
The, who was assaulted, how is so motorcycle thereafter basically assaulted is not there. And specifically name is not been mentioned.
Minor.
They thrown the bench and for the roof which they fell down.
When they fell down, they are assaulted from the victim last line matter. Victim statement last matter line.
But it is serious down, okay? His
All of
name
them.
is
Not particular, but all of them.
and their plea is that they were sitting in the
My lord, that is their
bench,
their defense.
they were coming in a high speed
My
and
lord,
just
that is their defense.
hit on the bench and they fell away. And immediately, as per them, they only took them to hospital.
Hospital, that is also there.
I don't know. Where's the PM report?
My lord, I have like my.
I
That's me in the lower portion. My lord, some injury, several injuries that some parts also missing. My lord, that is
Some
parts also missing in the injury. My lord. Hospital.
PM report is not
Lower portion.
complete, no?
My lord. My lord,
Injury number 3, which we are seeing that some tips of fingers along with the bones are missing.
my lord.
That cannot be accepted by. For that injury, there has to be very simple market will not do.
My.
But this is most probably, I think so, when the motorcycle was dashing around so and so, it was dashed on the ground or road, I think. For that reason, these things,
My.
the nails and oils were
My.
missing.
Missing.
Seems so.
Seems.
For injury, specific injury to that area, it needs requires some specific assault or by something.
My lord.
Otherwise, such kind of injury
No,
is
no.
not false. Hard Mr. P.K. Roy should be taken account. And hard will be sit. Is Mr. Chaudhary that the present his petition exempts it's not all whereby it's disciplinary incident whereas the information was received by police station on 1 there is such explanation why the delay of product subject is specific allegation how the victims were escorted by the accused persons. But the petitioner is in custody since last 58 days and does the IO was sufficient opportunity in keeping there are sufficient opportunity against where with the victim along with the deceased were coming in a person for which they sustained with the person. The same time, it also alleged that they fell down from and they fell down from the side. They all assaulted them and the one person was there for hearing the case report is that there are some second that there is the I got sufficient opportunity to hit them. And since petitioner is in custody, since that's to take this aspect, other matters in the case that you were granted with me.
Closed.
Please. Yes. Yes, what is 27 position?
CD not received, madam.
CD not received.
CD not received.
Are you on interim?
Yes, your lord. On last occasion, my senior had also mentioned that we are also not aware and we charge sheet has been submitted, but no update was.
Oh, yes, yes.
we did-
Do you have any update in that regard?
My lord, not my lord today.
As per the office note, nothing has been received on that end as to suggest what has happened in the case.
No, office not may not be
Okay.
required
No,
to say anything, but the
no.
question is that whether
27
whether
no, not
we-
action, no? No, not action.
on the last occasion there was a submission made by the counsel for the petitioner that as per the instruction case may have been ended with the charge sheet.
Right.
But and your name may not be there, no? Oh, I don't know what
Right.
it was the submission. Anyway, so you could have take instructions from the
My lord.
IO concern as to whether any
To be mine, I'll take telephonic instruction. But that's such a committee will be.
and in the same time you have not received the case diary.
Yes, they are not.
So when you can take it, your instructions.
Long.
Lordship may fix it on my lord. 9th, my lord.
9th.
Since it is a
But
for a long time.
a longer date, and finally we would know if there is a charge sheet, if it has been submitted. Otherwise, last time also short date was fixed, so no update could be taken.
Then my lord 18th, my lord 18th.
18th. Mr. No, Mr.
A. Mishra on behalf of Estas.
You're on 27. A with A appearing. You are A.
Mishra on
Mishra.
behalf of Mr. S.
Mr. A. Mishra appearing for Mr. Aston. Mr. Mishra. Sitting. Where it is submitted by Mr. Mishra that in the order of petitioner to take instruction as to whether the case has been, whether the charge has been practiced. Your best the petition PP thereby take necessary instructions from the concerned IO as to whether the case has been charge sheeted or not. And in the meantime, it take up to the case that we also call for if the charges is not yet paid. Let the matter be listed. 18.3 you are saying?
Mine. 18th, my lord. 18th.
Interim.
Deeply obliged, your lord.
Happily, Lord.
My lord, here charge sheet submitted, my lord.
Are you on interim?
Yes, my lord. I'll appear, my lord.
To appear. Art, you are Mr.
I'm Rahman.
Mr. M. Rahman. P. Sharma, the translation. It is submitted by Mr. Sharma that case has already been charged by CS number, yes?
I charge sheet number 223 of 25, dated 21/8/25.
it is an appeal.
Right.
In that case, we are extending your interim till 15 days, appear before the IR.
All right.
Yes,
May I please, Your Lordship?
yes,
Lordship,
we have received the case date.
Lordship, vernacular FIR page number 17, Lordship. May I read, Lordship?
Yes.
FIR laws on 28/7/2025, Lord. সন্মান সহকাৰে আপোনাক জনাওঁ যে মোৰ জীৱন মৰণৰ সমস্যাৰ বাবে মই মোৰ নিজৰ নামৰ মাতৃ বিক্ৰী কৰিছিলোঁ। সেই সূত্ৰে লাট মণ্ডলৰ ওচৰলৈ যাওঁতে লাট মণ্ডলজনে মোৰ পৰা পাৰ্মিশ্যন এণ্ড ৰেজিষ্ট্ৰেশ্যন উলিওৱাৰ নামত 90,000 টকা দাবী কৰে। লগতে মোক পতিয়ন দিয়াব বিচাৰে যে উক্ত ধন বিভিন্ন অফিচাৰৰ লগতে চাৰ্কুল অফিচাৰকো দিব লাগে। মোৰ অৱস্থা দ্ৰুত অৱনতি হোৱাৰ বাবে মণ্ডলজনৰ কথামতে বিচৰা টকা মই বাসগৃহত তেখেতক দিওঁ। পইচা দিয়াৰ সম্পূৰ্ণ তথ্য মোৰ হাতত আছে। উল্লেখযোগ্য যে টকা দিয়াৰ পাছতো পদকীয়া মণ্ডলজনে মোক সুদীৰ্ঘ 40 দিন পৰ্যন্ত মোৰ কামটো হাত দিয়া নাই। মণ্ডলজনে দেখুৱাই দিয়া চৰকাৰী মহৰীজনে মোৰ পৰা 4,500 টকা লৈ কোনো কাম কৰা নাই। That was the allegation, Lordship. Lordship, FIR was registered under section 3082, 3085 and 351(2) of BNS, Lordship. In this FIR, Lordship, the main ingredients of section 3082 and 3085 are absent, as there is no allegation either in the FIR or in the informant statement of any threat of death, grievous hurt, or criminal intimidation of attributed to the petitioner, Lordship. And our Lordship, co-accused was arrested and he was released on bail on the same day. The order passed by the additional CGM Tezpur, Lordship. Can you peruse the page number 23, Lordship? On this ground, he granted bail, Lordship. Third paragraph, Lordship, page number 23. Since none of the non-bailable offense prima facie apply to the fact of the case, and the IO has not been able to establish a clear connection between the invoked sections and the LS Act, I find it to be fit case for grant of bail, Lordship. After that, Lordship, the co-accused are released and pass interim order, this instant case, Lordship, police added 7A of the PC Act, Lordship. And Lordship, petitioner statement already recorded, Lordship. He cooperated with the investigation, Lordship. An interim order passed on 19/8/25. Already 6 months already passed. So my humble prayer, Lordship, kindly grant prayers bail, bail, Lordship, with any condition, Lord.
That is a statement of
You are granted with interim.
Yes, Your Honor. Order passed on 9/8/25 by this honorable court.
It is his statement, Lordship. And he has also admitted at the same time, Lordship, the co-accused, the Mohori, the clerk, he has also implicated this person. That because of him, he has to take 10,000 rupees. And he also knew that this person has taken some amounts. And apart from that, also, Lordship, witnesses also implicated him, and that he has taken money. And he himself has admitted that he has taken, apart from 10,000 rupees, sometimes in 10,000 rupees, he has taken 90,000 rupees for only for a mutation. So 90,000 rupees he has taken, and that too he did not complete the work. So this is how he is doing his job, Lordship. So this is because of these persons, petty persons, are all the common people are suffering also. Only because that he has come and he has stated also that he has admitted that he is cooperating. Cooperating doesn't mean that also that he has admitted his guilt also.
So we will face trial, Lordship.
And at the same time, 7A is also added. PC Act is also added. So at this stage, Lordship, this person is not entitled for the
FIR laws on, Lordship.
MFC case has already also been made.
28/7, Lordship. Already 6 months already passed. Or investigation on 6 months already completed. We will face trial, Lordship. Any conditions, Lordship? And every occasion he appeared before the investigation officer, Lordship, when required.
Any IO notice there regarding the objection?
That is the, that is I have
Clear
taken,
interrogation will be required.
Lordship.
I mean, admittedly he appeared and cooperated, and he, to some extent, he admitted his guilt also. And whether any related documents, etc., are to be, is there any?
That,
Because the prosecution sanction
that
is
is the,
also there. As 7C, 7A has already been. That's true. Who was the arrested person?
Lordship.
One person also got
Yes,
arrested.
his
Is
name reflect in the
Is Bolen Malaka?
FIR. Yes, Lordship. Bolen Kolo, he's a clerk. And he was released on same day. Lord.
Obviously, from the FIR and reading, most probably 308 and 3085 will not affect.
That,
It's there's no such kind of threatening parties.
threatening part is not there.
But the question is that the 7 APC Act has already been released, and that about 351, 35 is there. Be any documents to be collected to be. These are also not there.
CDT was not asked for CDT was. CDT.
You are Mr.
Emboradors.
Hard Mr. Emperor, Hard Mr. Yes, comfort. It's an application. So submitted by Mr. Gauhati, the representative petition. It's it's not committed. Most security cases registered under section 308 to 3085 BNS, but there is no intelligence to affect those sections against representation. Considering this aspect and one of the co-evidence has granted bail on the day of this order of arrest. Considering the case of representation, same in the released reading the order of interim bail dated 8/19/8 he already appeared and cooperated in the investigation of this case. Investigation. He is still ready to extend this further cooperation if it is he is provided with privilege of pre-arrest. Next, Mr. 49% submitted to there is some the petition who himself admitted that he took the said amount mentioned in the FIR in the name of nutrition to be done in the name of nutrition body from the book. He appeared investigation, but during the pendency of the investigation and considering the fact that the petitioner is a government employee, section 7C of the PC Act is also
7A.
sorry, 7A of the PC Act is also at the by the learned based there. Mr. Locker submitted that the information will be for the purpose of the investigation. Here is submitted. It is not a big case to extend the privilege of the bail. Yes, Locker, anything we found that I mean, suppose he is a government employee. If anything, any documentary evidence is required, or any, or if there is any probability of hampering and tampering of these documents. That observation could have been made by the IO, but there is no such observation. I've seen. Rather, his evidence statement is recorded, that much notice also. Could have been any such kind of observation. Obviously, he admitted his guilt before the IO. An investigation cooperated in investigation, but cooperation definitely you are saying rightly that cooperation doesn't mean that he appeared in that much. But there is no other note in the IO that he was supposed to provide those documents or departmental inquiry.
Document was required, but he is not submitting. That is not.
No, that is during his submission made by language. I also said he is died. Is founded after the order of temporary arrest failed. Petitioner is cooperating in the investigation. And further considering the other matters available in this diary, I find that custodial interrogation would be required at this stage, and there is substantial progress in the investigations. Accordingly, I find it a case to accept the privilege of the presentation. The order dated 19/8. No, order of interim period is bill dated 19/8/2025 is hereby made absolutely with same.
You haven't received the CD, Lordship.
They have received.
He is on interim. CD not received.
CD not.
Interim received.
Are you on interim?
Yes.
CD not. CD should remain. Yes, when it can be listed.
On 16th of March.
Interim may be continued. 16/3. It may be continued. Listed. You may continue on your.
This case CD was earlier CD was received, but the person was on interim. So his statement was not recorded. So it was sent back, but now we have not received.
Now you have received.
No, we have not received again.
Not received.
Second time we have not received.
But he is not present.
He's an interim.
No one has represented the petition. However, it is submitted by Mr. Long that a updated case diary is not received by the receipt, the IO. He issue reminder for updated case diary and with a further direction to the IO to serve the to furnish the copy of the statement of the petitioner if already. It's the matter accordingly on 16 pages. Interim be continued till 7.
The 32 case that was called for.
Here also we have
not received. CD not received. Issue reminder. Yes, when it can be listed.
The interim may be continued, madam.
On 18.
In the last occasion also it has not been received. So ask the IO to release on 18/3, list the matter on 18/3, interim be continued till next.
I have queries.
Yes, what is the position of 33? CD received. CD received.
May I please, Your Lordship? Lordship, it's an application under 482, Lordship. Petitioner was an interim, Lordship, and he has appeared before the IO, Lordship, pursuant to that interim order, Lordship.
Interim was granted on 9/1.
9/1.
What is the case about?
The case, Lordship, will see
69.
a major girl, Lordship, she alleged that
It falls from his marriage.
Lordship will find the
69.
FIR. Yeah.
69.
69 is there. If Lordship will go by the FIR, Lordship, at page 7, Lordship, that on promise to marry, and he has taken some money from her, and also was in a physical relation with her. And after that, he refused to marry, then she lost this case. This is the allegation.
What she do, in fact,
No, Lordship, these are false allegations, Lordship. From
what
where
why
she
I'm
is.
saying 30 lakhs is a,
Yes,
3
Lordship,
lakhs.
huge.
3 lakhs. 3 lakhs.
oh, is 3 lakhs.
My
So your translation is wrong then.
my lord.
No, Lordship.
Hmm?
In the vernacular also, Lordship, there are five,
Eh,
many zeros.
Many zeros are there.
Mm.
Where the vernacular is in which page?
Page
Page
12.
12. More pora.
But in
The
her
vernacular is, the figure is in English, Lordship.
one more zero is there.
If it is 60, then to 30 lakhs will be
My lord. But in her 183 statement.
3 lakhs. Anyway, yes, what is your submission?
My lord, receive the case diary, my lord.
Hmm.
And from the case diary, my lord, there is the allegation, my lord. On the pretext of marriage, my lord, he has committed, my lord, several times sexual offenses, my lord. And my lord, from the medical report also, it reveals, my lord, some symptoms are there, my lord, regarding the, my lord, pregnancy, my lord. And she was asked to go for ultrasound, my lord, after 1 year, my lord. That report is also there, my lord, in the PM report, Lord, my lord. Oh, no, my lord, sorry, my lord.
Medical report.
Medical report. And allegation is that the accused petitioner also taken 3 lakhs rupees from her mother in several occasions. But that is the allegation.
I have already appeared, Lordship, and I'll cooperated the investigation, Lordship. If it is charge sheeted, Lordship, then I'll face the trial, Lordship, if anything comes out. Because now these things, Lordship, this I am denying, Lordship, this 30 lakhs or 3 lakhs. She has not, I have not taken any money from him.
What about physical relation? You were hit.
Lordship, there, actually, she is known to this petitioner, Lordship, as a friend, Lordship. And now she is 32 years and the petitioner is 27 years, Lordship. There was some relation, Lordship. But as per my inspection, Lordship, he has not committed any physical relation. But she wanted him to marry her. He refused. Then this case was lost. Even in the FIR, it is there.
But 2033. Authorization of CD receipt submitted that with some content of the delegation, the FIR has been lost against the petition. It is the fact that there was some relationship between the victim and the petitioner. There was no such physical relationship between them as alleged by her. However, after obtaining the order of rearrest, he appeared to the cooperated in the investigation of this case. He is still ready to extend his cooperation for the investigation if he is granted with privilege of the district. Next question, Mr. Sharma, the learning that the victim in her statement recorded under section 183 BNSS brought sufficient allegation against the present petition, showing his involvement in the arrest. However, he submitted that the accused petitioner appeared before the IU after obtaining the order of pre-arrest bail, interim pre-arrest bail, and his statement is also hearing the submission the case diary and considering the matrix in the case diary and that as to the interrogation and the required for candidate with the privilege pre-arrest bail present. And accordingly, the order of interim pre-arrest bail dated 9/01/2026 is hereby made absolute.
Oh, very good.
Please, your lordship. Lordship, the petitioners are already in interim bail, lordship, and they have appeared before the IO and recorded
Just
their
a second, have you
statement.
received the case?
My CD receipt.
Yes, what is
After
submitted?
interim, he has appeared statement also recorded there. Two petitioners are there.
How many? Two.
Two petitioners are.
Lordship, in the meantime, Lordship, the informant has sworn an affidavit to the effect that she has lost the FIR due to some misunderstanding, and she is willing to not to continue this case, Lordship. That part has been already recorded in the previous order by this Honorable Court, dated 30/1/2026.
But whether this that affidavit or compromise notice
My
dated
lord here. Lordship,
in
kindly
case-
please, my lord.
The original was submitted.
Yeah.
Sheikh,
M.R. Karim, my lord.
Mr. Bishop, the learned edition, submitted by Mr. Karim at the obtaining a pre-arrest, interim pre-arrest bail dated 30/01/2026 already appeared and cooperated in the investigation. Further, he submitted that after filing of the FIR during the pendency of the investigation, the matter is already set and a petitioner and any victim also sworn an affidavit to this regard, stating that due to some misunderstanding, the case was moved by Mr. Shah, the learned that the copy of agreement is available in the case diary, and it is to petitioners also appear before the and corporate institutions in view of the submission made by the constitutions. Considering the matters in case I find that has to be interrogation in a dated 30/01/26 is here.
Obliged, Lordship.
Maybe.
Yes, what
My
is
lord, here we have received the case there, but his statement is not here, my lord. After interim, whether he has appeared or not appeared, my lord,
for your instruction? Do you
Lordship,
have
he appeared.
When appeared?
which date?
Lordship, did I may not, Lordship, at this stage, I have to take again instruction, but as from instruction, he already appeared.
Appeared in his cases.
Statement is recorded.
It is your affidavit. I mean, CD is up.
My lord, last up to my lord, it was 10/2, my lord.
10/2.
But
This order is of 5/2.
5/2, my lord. Here also not reflected any, my lord, whether he has appeared. Here
And
it is,
copy
my
of order is there? No.
my lord, no.
Copy of order is
No,
also not. That means you have not appeared.
my lord.
No, Lordship, within the short period, Lordship, the CD was sent back, I think 5, the order was passed, and CD was sent only on 10, and the order was
Not
given.
CD was say last entry.
And yes. Because thereafter no entry was there, because the order was given 7 days time to appear. After 10, he may
No,
appear.
maybe you may appear after 7 days.
Yes.
I'm not on that. Whether you have appeared.
As per my instruction, I may admit him. Still, I have appeared.
Lordship, may call for update, my lord.
Otherwise, Lordship, the case of the affair, Lordship, it is a
That is there, my lord. But here, my lord, in the last, my lord, I will note, my lord, it was house search also made in his house, my lord. But he was found not available in the house, my lord, and he is absconding, my lord, found absconding to avoid the police
Which
arrest.
date house search was,
That is 10-2,
but
my lord, that is also
direction
up to date.
part which aged amendment related council.
Yeah, what is it? Yeah, yeah.
City receipt
এনেকে ক'লে নহ'ব ন ওপৰতে
and
এনে এতিয়া
city
জানিব
receipt,
লাগিব
but the statement of the present
আপুনি বিশ্বাস ল'ব পাৰে কেতিয়া হৈছে
is that
ল'ব পাৰে
in that context.
না না এটা ফোন কৰি হ'লে
They have already appeared.
Lordship, one thing I suggest, Lordship, let him take instruction
No, no,
yeah,
my lord.
on second or fifth, Lordship, whether he appeared or not.
No, no,
As per
not
Mr.
necessary.
He appeared, Lord.
মই কিয় ল'ম
Before their statement is also recorded as per his instructions. But as the statements are not available in the case record, and it is also seen that the case diary is and the last entry of the case diary is of 10/26, and the order of the interim bail was passed on 5/6. Where in view of this, the IO is hereby directed to furnish updated case diary and also to furnish the statement of the petitioners if already recorded. And in the event if the petitioner's statement is not yet recorded by the IO, they are asked directed to appear before the IO within 7 days from the date of order. Let the updated case diary be called for. Yes,
24th month
24/3/6. Interim be continued. If your statement is not recorded, again,
Right.
I am asking you to appear before within 7
Okay.
days. And this time, if suppose if there is any failure in recording, then automatically
No, no,
your
sure, sure.
bail will be.
Always.
36. 36, what is the office note? Oh, you have already appeared for informant.
Yes.
Yes, okay. And the case diary you have received? Yes.
Lordship will find the affair at page Lordship 22.
30,
22, Lord.
20.
Lordship. Original affair, Lordship. Lordship got it, Lordship. Affair lodged on 20th November 2025. 2011, 2025, Lord. Lordship, may I read it, Lordship? With due respect and humble submission, I would like to intimate you that I am the proprietor of MS so-and-so, 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 Assam. For initiating legal proceedings, I have executed an authority letter in favor of Mr. Sanjay Kumar Sarkar to initiate legal proceedings. By virtue of the said authority letter, Mr. Sanjay Kumar Sarkar initiated a writ petition before the Honorable Gauhati High Court, High Case number WBC number 6752/2024 against the state of Assam and 5 others. After hearing both the sides, the Honorable Gauhati High Court was graciously pleased to pass an order dated 25/02/2025. It is the disposal order of the writ petition, Lordship. Directing the respondents to refund an amount of rupees 4,61,10,097 only in favor of the MS Sayana Traders, proprietor Sri Sanjay Kumar. In spite of the said order dated so and so 25/2/2025, passed by the Honorable Gauhati High Court, the respondent failed to refund the amount to the complainant, for which the complainant again initiated the contempt proceedings against the said respondent. Lastly, on 29/10/2020, the Honorable Gauhati High Court was pleased to pass an order and listed the case on 21/11/2025 for hearing. It is worthwhile to mention here that I have instructed Mr. Sanjay Kumar Sarkar to deposit the refunded amount in favor of either the account of my proprietorship firm, a white account number so and so lying with the State Bank of India, Jogikopa branch, or in the account of the accounts of white accounts number so and so lying with the Axis Bank, Valdola branch, Gauhati, in the name of the signer trader.
That means, who was authorized to file this writ petition? You.
No, complainant, Lordship.
It's a complainant was authorized.
Complainant authorized the name accused of the affair to initiate a legal proceedings. Accordingly, he instituted the writ petition, Lordship.
No, who instituted it? Who is the person who
Sanjay,
instituted?
Sanjay Kumar Sarkar.
Sanjay Kumar Sarkar.
On behalf of Lordship, Sanjay Kumar, the present complainant. Complaint was lodged by Sanjay Kumar.
Can I clarify? He had a tax refund. Jimma trader is the name of the. The important the Sanjay Kumar is the proprietor. He, the main accused, Sanjay Kumar Sarkar is the main accused. He was authorized by the firm to take all steps as a power of attorney. What he did, he had proceeded with the heading of case and subsequently he also took part with the processing with the department. When the lordship, the direction was issued and there was a direction to refund this amount, 1.61 lakh, it has to be refunded in the name of the proprietor or the firm on whose behalf the case has been filed. He was only an agent, Mr. Sarkar. What he did, in connivance with this accused person, he opened an account and there that money was transferred. So it's a case of impersonation. So in order to grab that amount, he has opened a new account in which the government has transferred this. Say, sign up a proprietorship form. Say, I have been sanctioned. Somebody opens the account in my name and get this amount. Now, out of that amount, as per instruction, 90 lakhs has already been withdrawn or 70 lakhs has been withdrawn, balance amount has been seized. Now, this accused person, or the present applicant before your lordship, is the person who has gone to the premises of the main accused and identified him as the proprietor. And he has also identified the address. Which can't be, because this gentleman is already having a bank account in some agro firm of his own account in the same branch. So he is very well not connected with the bank officer. That is how this entire thing has.
He identified
The
another person as a
proprietor.
proprietor.
New account would be open and this amount would be deposited.
Actually, he is the source person, and his duty is to he has some as per his own statement that he has some target so that he can open new accounts. And what he has done here, he without visiting the place where he researched where their office is, and without identifying whether this is the that person, and this is only the person who is going to be open, without verifying his signature, he has opened that account.
Otherwise, this person is the bank official.
Bank officer.
Bank officer.
And here branch manager is also involved.
He has done lordship actually as per the instruction of the branch head lordship. He is the in the position of the clerk lordship. As per the verbal instruction of the branch head lordship, he had done the necessary formalities lordship for opening of the account. Accounts was opening on 22nd October 2024 in the name of the present informal lordship. 22.
Present informant, it's not there. You identified someone as a person as a proprietor of that company. There is this Sanjay.
Admittedly, lordship, the information was not present in the bank, lordship, and he the present accused present petitioner also not visited the premises of the informant. That is true, lordship.
Will not be available in bank because it is not his account. The account is not open in his favor. It was
Lordship.
account is all the government money which was
Yes.
ordered by this court been credited to that account only.
But he is going to say that also that the present accused person was not there at the time of transaction of that amount. But because of his
Initiative.
his entire look after, that account was opened. That the opening of account itself is a illegal act.
Lordship, I have the
That
second
was
page.
not being done.
Second
The
page.
amount would not be transferred. Only because of that account is being opened, that amount is being transferred.
So I'll come to the text, Lordship. Lordship, kindly come to the second page of the FIR, Lordship. Page 23, Lord. Meanwhile, from the reliable source, I come to know that the below named accused persons, along with the bank officials and some other persons with ulterior motive, have forged my signature using my credentials without my consent, created an account lying with the Notice Financial Small Finance Bank by the account so and so at the Rani for the stock so and so, Lord. But not with a false document, Lord. Without the consent of the present informant, Lord. That is also important, Lordship, I think. I may be wrong, Lordship, but using the credentials, not by the forging any documents of the present informant, Lord. And when the affair was lodged, Lordship, it was lodged on
Many you want to submit
2011.
that the documents or the identity which were produced were the original.
Actually, he was to
all his credentials were used.
Lord, pardon, Lord.
All his credentials were used.
Yes, yes.
But one more sentence is there that they forced your signature also.
Yes, it was not by me, Lord.
Yes, it is not.
It's not by me,
not
Lord.
by you.
He has a limited duties, Lord. He is not the head of the institution, bank. He has done under the instruction of the branch head. And the affair was lodged on, Lordship, 20 November 2025. And contempt petition was pending up to 21/11/2025 before.
FIR is the page?
Affair is 22. 22.
No, FIR laws on 23/11.
No, Lordship. 20 November 2025. 2011 to
20.
yes.
FIR was law.
Lordship.
And your contempt proceeding, the order was passed on?
It was pending till 21/11/2025. The final disposal was, Lordship. Lordship will find it at page, Lordship, 28. Contempt proceeding, Lordship. Lordship, kindly have a look, Lordship. That is also important, Lordship. Page 28 and excerpt 5, Lord. Lordship got it, Lordship. The telephone was at 29. Heard Mr. So-and-so, my learned friend, Lordship, who has appeared on behalf of the informal, Lordship. It is submitted by MS RM Bodwa, Learned Counsel, appearing on behalf of Mr. B. Gogoi, Learned Counsel, for the alleged contempt noted the order dated 25/2/2025. Asked in WBC number 6753 of 2025 has duly been complied with by passing and speaking order. It was not there, Lordship. It is not reflected here. It is noticed that a refund tax amount has been paid by the authorities to the petitioner and the claim of interest after examination and consideration has been rejected. Principal amount was released and interest and the claim of interest after and consideration has been rejected, Lord. In view of the above, the order dated so and passed in WBC has been duly complied with. It is needless to observe that the petitioner may avail a remedy as may be permissible under the law with regard to rejection of petitioner's claim for interest in his concern. Actually, this contempt petition is then closed, Lord. By order dated 31/2026, contempt proceeding was closed. FIR's laws, Lordship, 25/11/2025. Accounts was opening on 22nd/10/2024. More interestingly, Lordship, he was transferred from that branch, Lordship, particular branch, Lordship, on 24/12/2024. Lordship will find that order, Lordship.
No, but the contempt case proceeding cannot be related because it was the order passed by in the contempt proceeding regarding the compliance report.
Compliance.
It is just submitted that it has already been compliant. That matter has been. I mean,
This is the
it is
what has
deposited.
happened. But the main accused, he knew that the refund amount will be sent because there is a direction by the. What he did in connivance with the bank officials, he had already opened that account.
For earlier to that.
Earlier,
Oh,
the culpability of the present accused is this, Lord, that he did not take his due diligence. He was to verify and all. Because
That
of
is
his
true.
wrong verification, the account was open and he could misutilize that amount. It's not that after or for, that has opened long back and it was a design by the main accused. That I'll have an account in this name and when the refund would come, then I'll get this money in my account.
That is the actual cash, Lordship. Actually, he was not verified details of the present complainant, Lordship. Without verifying
The
that.
question is that he definitely he is on his part, he is the default that he has not verified the detail of dissuasion.
So that is he's supposed to, that is the job he's been made to
That is
learn.
his job. But
Tomorrow if-
all the credentials were used by the main accused are your documents now.
Third, my submission is, if my credentials are used, then you will show my Aadhaar card.
Yes, obviously.
So what has happened is, by opening that account in the name of the firm, if he declares himself as a proprietor, if the office of registered office as his own precedence, then there is a culpability on the part of the verified officer. Otherwise, every time this kind of mischief would happen. And it's not that it's one-off account. He is an existing account holder, the main accused of that bank. He has got good connections, and that's how he had could make out this plan. He knew that this is going to come that way. Otherwise, what was the purpose of opening a court account?
It is the branch head, Lordship, who actually verified all the documents, Lordship.
You has done on the basis of direction. It's become more dangerous, Lord. The entire
Definitely,
machinery
Lordship,
is
that's
involved.
subordinate officers always do, Lordship, as per the instruction of superior officer. Lord. And accounts was opening on 22
Commit a crime, and that's the
October
direction to be
2024.
followed.
Let me finish my. Accounts was opening on 22nd of October 2024, Lordship. Thereafter, he was transferred by order dated 24/12/2024. He was joined in a new place of posting, Lordship, on 1/1/2025, Lordship. As per from the perusal of the
Transfer on which date?
Lordship.
After opening of the account?
That is true, Lordship. After
Then
but
what?
transaction was happened, Lordship.
Whatever, but the bank account was open in your presence when you were in in
Some
that place before
I have
your
already
before your
admitted,
transfer
Lordship,
and all.
negligence was there, Lord, on the part of me, Lordship, at the time of opening of the account. That is, I have admitted, Lordship. But transaction was when it was happened, Lordship. That's happened in the last part of the
But the
2025.
transaction would not have to happen if that account was not open.
That's what I have admitted.
In connivance
That's
with,
what I have
this,
admitted, Lordship.
bank officials or whatever.
Anyone comes to bank that I am going to open in the name of that person. Who is that person? That has to be identified. His signature is required. His initial, his bank signature is specimen signature is required. How and that specimen signature has been forced, and that has to be taken in front of him. So he has identified that this is his signature. So everything is done.
Allegation is false. Allegation is false, but using the credentials of the informant, Lordship, may not be false also, Lordship, because the name accused to produce all the original documents also, Lordship. Nowhere says this the manufactured the documents in the name of me, Lordship, using my credentials, Lord.
Yes,
Using my
manufactured the signature
credentials,
only.
Lord.
That's that much, Lordship. And if for bank transaction, that signature is the everything. If I can
And still-
sign his signature, then I can do anything, Lordship. So for bank transaction, the only part, the most vital part is the signature, and that has been forced. That much, Lordship.
That is the allegation, Lord. That is the allegation, by forging my signature and using my credentials. That is the allegation, Lordship. I have fairly admitted, Lordship, at the time of the opening of the account, Lordship, I have not went to the privileges of the informant to verify all these relevant documents as well, or not, Lordship, that's verify the signatures, etc. Lordship.
That statement itself is culpable, because I am not a resident where he has verified. He says that he has gone to my place.
He has not gone to your place. He is saying
He has
Admitted,
gone
Lordship.
to the
I have-
premises of the main.
I have done whatever I have done, Lordship, as per the instructions of my branch head, Lordship.
Party.
Branch head, Lordship. And nobody has approached before this court, Lordship, in this in connection with the present affair, Lordship. The police only harassing me, Lordship. Even not by the name accused has approached before this honorable court till today. I have entered in the website, Lordship. That is also important, Lord.
hard Mr. B.K. Gogoti
But to kindly protect me, Lordship, I will appear as in when required by the IO, Lordship.
He is not for the learned edition. And Mr. R to be the learned counsel appearing for the court. It's an application, section 12, CD receipt. Failed receipt. Next, it's submitted by Mr. Gupta, the present accused petitioning. He has not committed any such as a However, he admits that there is some thought on his part at the time of verification, as there was some defect in verification, as the verification was not duly done at the time of opening the account in the name of the. However, from the FI itself, it is seen that the account was opened on the basis of all the credentials of the informant, which were produced before the bank authority, and he, being the subordinate to the bank officer, had also complied with the order of the bank manager at the time of opening the account. The further submitted the account was opened on 22/10/2024, and thereafter he got his transfer on the month of December 2020, and he was never present in any kind of transaction what had happened in the said bank account. However, he is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interpretation. Next one, Mr. Blockford Learned Additional PP submitted in this regard that the opening of the account is itself illegal. It itself is illegal, wherein without any proper verification of the person concerned, the account was opened, wherein the other bank officials also involved in operating and opening an account in a fictitious name. He further submitted that he is the person who identified the proprietor of the company, who proprietor of the company, that is the informant, without even visiting to his place of residence and without proper verification of signature of the informant. Accordingly, he raised objection and submitted that this custodial interrogation may be necessary for the interest of the. Next, Mr. Ruby, the learned counsel appearing for the informant, submitted in this regard that the account was opened on 24/10/2024 by the prime accused, one Sanjay Sarkar, with every knowledge that there will be an order of refund of the tax amount, and in that view only, the account was opened prior to the order passed by this court and order passed in the contempt proceeding. He further submitted that in connivance of the bank officials, including the present petitioner, the open account was opened in the name of the proprietor of the firm without any verification, doing any verification, without even visiting to the place of residence of the informant. He further submitted that the informant resides resides outside Assam, and from the conduct of the petition itself, it is seen that he never visited to the house for verification of his signature and other credentials, on the basis of which the account was opened in the name of proprietor of the farm. In view of this, Mr. Ruby, the learned counsel for the informant, also raised objection and submitted that it is not a case for granting free respect to the and his custodial interrogation may be required for the purpose of investigation. Okay, I'll produce the record. I have recorded your submission. You have marked it some, Mr. Blockford. You have marked